Item 1. 19. With your lordship's kind permission, I am filing the review application and the delay petition on the basis of which the impugned order has been passed. On the last occasion when the matter was heard, the then Honorable Bench was pleased to observe, though it is not reflected in the order sheet, my lord, that I should file these applications and also a date chart, my lord, indicating the dates.
Let them stop the.
But I'll just also clarify one thing.
Where are you filing? Have you filed it in the registry?
No, man, I am
all
filing.
Applications, your rules say all applications should be moved, petition should be moved, appeal review petitions should be moved before the registry. They will know whether it is in format or not, whether there is delay or not.
I am not filing any application. The document that was asked to me to be filed on the last occasion, and I am giving a copy to my friend.
Last occasion means you are referring to the order of 28 February 2025.
My lord.
24/11.
That order is not there.
The Honorable Bench of Honorable Justice S.K. Sahu and my Lord Justice S.S. Mishra, my lord.
No.
Well, a date chart along with the miscellaneous application and review application which were filed.
It is not uploaded in the
And I am giving a copy to my friend. My lord, the date should be only 2 dates.
Just check it out.
I'll point out to your lordship.
Just check it out. Both the.
Previously,
that order is not here.
Just check it up.
The order is uploaded.
No, that's right. But in my
it is not simultaneously uploaded.
I'm so sorry, man.
No, it's not. It is not your mistake of the registry.
My here what has happened.
I will read for a moment the order of 24/11/25. Mr. So and so, learned senior advocate appearing for the petitioner seeks to adjourn the matter to some other day so that he will file a date chart along with the miscellaneous application and the review application, which were filed before the learned Central Administrative Tribunal and came to be dismissed by virtue of the impugned order.
That I am filing today with your lordship's kind leave. Now here what has happened. Initially I joined as a caretaker under the railway. Then there was a provision for appointment to the group D cadre.
No, why we should hear you?
The limit is
You follow this, comply with this order first.
That
I
order,
can hear you.
I have complied that order, madam.
You have produced those things.
Madam, that is what I am produced with your lordship's kind leave, madam.
Now they are produced.
But those dates will not be necessary.
But these are production of documents.
So
Production of documents.
Documents also I have filed, madam.
That's all.
Document also I have filed. I will only point out 2 dates only, not beyond that.
No,
Yeah.
what? Madam, I prepare 10 days time to go through the review application. Already, you lot of directed the last occasion due to the hearing of the.
You are not a party to the review petition.
Yes, I am the party, but review.
Then what will you read the review?
They have not annexed that document. That's why your lordship directed to file a review application.
This writ petition is arising out of the review as well as the original order. You are a party to that. What review petition will read? Read this writ petition.
I have
Circulated a lease update. Let us go through the lease update.
and they have filed.
If you have a case, then it's all right. Otherwise,
I'll only.
Next week I have go through the review application. My lord, they have filed.
Not review application here. But my brother is saying
They have
review
filed there.
application was filed there. Even for people's copies we needed. That he has produced.
what he will be
Production of documentation.
Yes, my
You appeared before the CAT.
No, my lord. That's why.
The government
I have applied for
maybe other government council.
That's
And here, my lord, what I am saying,
paper next week, my lord, I will go through the review application. What the ground they have taken, that is the main purpose to.
And the lease update also is there.
Yes,
If
ma'am.
you want to
Yes,
prepare your lease update, prepare
Yes,
it now.
I prepare.
So that
Yes, ma'am.
and in fact, except 2 dates, no other list update, because the Honorable Court directed, I have given all the sequence of events, or other dates will not be required. Within a CMA application, he says liberty is granted to file a review. When I file a review, he says it is successive review, abuse of process of court, hence dismissed. That is the only point. So therefore, other dates will be irrelevant in the context of the challenge that has been made.
now you understood. What?
My lord.
Next week.
And
Next week.
এটা রহিব না?
Yesterday's
And these documents may be taken on record, my lord, only the review application and other thing. I will file it
You
in
file in the register.
so grateful, my lord.
Why have you opened it?
Filling it in course of detail.
Open it again.
Today's list they have not given to you. Item 2.
Like opposite my lord. Item 2 matters, I'm praying for adjournment.
Printing adjournment.
Because,
On what ground? You are appearing for the opponent.
yes,
Are you agreeable with the proposal? You should be little fast. The morning hours are very precious.
Yes or no?
yes, next week.
Yes.
Next week.
2 weeks.
But next week, because
Next week we have posted many. We do not know the same combination will continue or not. We can't post matters for the other bench. Therefore, let it come after 2 weeks. Let us see. 2 weeks at the request.
some of the judgments it has been misplaced, man. That's the reason.
Next. Item 3.
Obliged, ma'am.
3.
Yes.
That order dated 2/7/2024 at Annex 6, page 36. The subject matter challenge which has been passed by London Central Administrative Tribunal.
Subject matter you have not said. Only order is challenged. What is
Yes.
the subject matter?
Well, the subject matter is the charged official is charged with 3 charges. One is he was working as a branch postmaster, and during deposit of money by the depositors, even though he has mentioned all those things in the passbook, but has not deposited such amount in the BO account, my lord. This is because he is the custodian of such money, and he should have deposited all those deposits in the BO account. He has not done this, so that is why charge was framed by Annexure 1, that is at page 15. My lord may kindly come to page 15. Relevant portion is at page 16. Sri Swai, in the capacity of BPM, Nagarpada accepted the deposits and entered the amount of
Which page? We are not on the same page.
page 16,
16, 16.
16.
Okay.
16 is correct. Go to 16. Okay. You are right.
Sri Swai, in the capacity of BPM, Nagarpada, branch postmaster, accepted the deposits and entered the amount of deposits with his initial and authenticated the deposits by making stamp impression in the passbook, but did not reflect the 3 deposits in SB journal and failed to account for.
But the tribunal saying the principle of reproduction. Violation of principle.
Completely quashed or remanded?
No, my lord, it should have been remanded as the Lawrence Cat came to a conclusion, but subsequently said that since right now he is aged about 75 years, it is not correct to remand the matter back for fresh disposal, and accordingly directed the concerned authority to pay all the accounts.
No, but principles of natural justice.
Well, yes, of course, that is mentioned in the finding of the
See, can you please come to page 48 in order?
48.
Para 13 and 14 just read.
Yes,
Para 13 and 14.
48. 13.
13.
On examination of the matter with reference to the law and rules discussed above, the inevitable conclusion is that the applicant has been visited in gross violation of principle of natural justice and rules and in an unreasoned order by the DA and upheld by the AA, which is highly illegal and arbitrary. Hence, my lord, I am conscious about this
Yes,
fact
yes.
that principle of natural justice has been violated, but in fact this is not correct. My lord,
Whether it is violated according to you or not.
no, my lord, this principle is correct. But this principle has not been violated in respect of the particular charged official. He has been given sufficient opportunity to contest the case, and he contested throughout the proceeding. And subsequently, it is found that he has committed mistake. So that is why this punishment was imposed. Had this been so,
That money he did not remit to the
Yes.
account of the
yes,
department.
my lord, that cannot be
When
overruled.
he retained that money,
My lord, I could not follow.
Has he returned the money back? Have you recovered the money from him?
My lord,
what is your charge?
Charge-
Whatever amount he has collected, that he was to credit to the account of the department, which he did not.
did not.
Correct? And he pocketed that money.
My lord, if that has not been credited, then, my lord, it is the bottom duty of that person who is in official capacity to deposit all those things.
No,
The
but-
presumption is against him.
What my problem is asking whether it is subsequently paid back by this gentleman?
No, not at
to the
all.
department?
No, no.
That's
Not at all. Not at all.
Issue emergent notice. Take notice.
My lord.
Since OP is a super senior citizen, call this matter immediately after service. Okay.
Item
My
4.
lord, I have filed an IA. My lord, that CP contempt proceeding is being initiated.
Next one. Learned, your CGC,
My lord.
Learned CGC appearing for the petitioner submits that in terms of impugned order, since action was not taken, the contempt proceedings are initiated before the CAT, and therefore the same need to be halted during the pendency of the petition. First, there is force in this submission. First, in the above circumstances, the matter in the contempt petition, what is that? CTA?
My lord, that
What it
is
is called there?
contempt petition,
CP number.
CP. But my lord, that number is not available to me right
Contempt
now.
proceedings pending on the file of the CAT or kept in abeyance till still kept in suspended animation till next date of hearing. Yes. First. Next, since the above order is made ex parte, it is open to the other side to seek its variation if grounds do exist there.
Item 4. Item 4 may present. There is an adjournment under 2 weeks. Certified copies could not have been.
2 weeks at the request.
Yes, ma'am.
Next,
Item 5. Oblige.
Union. Madam, I owe an apology to you. I was a bit rude to you yesterday. I'm sorry.
We change the order also.
Well, this is the order.
That's
It
okay.
requires
Your
consent.
lordship, I know your lordship's magnanimity that your lordship will go through.
Correct.
We will hear you once again. Huh?
Sometimes that
We will hear.
I am the respondent here, my
In this matter, if you bring your friend, we can consider.
petitioner is not there, my lord.
Yes.
That they are
Person from
challenging.
the petitioner is, CGC is absent. CGC appearing from the petitioner is absent. Call week after next. Next.
Item 6. Item 6.
Counsel for the petitioner is absent. Call week after next.
Item 7.
In item 7, I have instruction to appear on behalf of opposite party bank.
I am for the
Lord, for
petitioner.
petitioner.
On the last date,
But you want to, you appear for the other side.
Today we are going to appear. We have instruction for the bank.
Are you ready in the matter?
No, my lordship, we have
Call week after next request.
lordship and one request. The name is reflected. Wrong name has been reflected on.
Name to be rectified. Give that how it should be. Yeah.
You have received the copy of the petition?
No, we do not have
Give
a
copy.
brief.
Give all copies.
yes.
Because she is looking at her mobile.
Uh-huh.
Doesn't have the file.
Yes, sir. Next.
Item 8.
Apology. Last time you not see direct file the regender, my lord. I am filing the regender today, my lord. Kindly taken on next thing, my lord.
Next week,
Yes, ma'am.
you want to file rejoinder.
Yes, ma'am.
Petitioner, counsel for the petitioner seeks accommodation to file rejoinder. Personal. Call 2 weeks after next. Next.
Item 9.
May I please your lordship, my lord, please make a glance to your lordship's order dated 13th October 2025, my lord. Please make a glance. Because your lordship was pleased to direct the P.K. Pahi, Learned Deputy Solicitor General, produce the entire service record of the petition and also order dated.
Why 13/10/2025 order was made? What have you done pursuant to this order?
Well, we have intimated, but till now we have not.
You go on intimating them. We will decide the matter, keep that intimation pending.
Only 2 weeks time.
No, what have you done? In October, this order was made. Where is the respect for the order? If the union government does not respect the court orders, why you should be heard in the matter?
Communication gap.
What communication gap? How many months? 13/10, 13/11, 13/12. Shortly it will be 13/1.
Only one last chance.
As a last chance. A period of 1 week is granted to the learned DSG to comply with the order dated 13/10/2025. Yes. Final.
Item 10.
My lord, with deep apology, item 10 and 11, both the matters. Can I pray that 2 to 3 days time, my lord, so that
After 10 years, my lord. Read.
only I am praying for
After
3
10
to 4
years.
days time, nothing more.
I'm-
3 days.
I am praying for 3 days only.
After 10
I have to
years,
get some instruction.
issue already decided by this honorable court in the case of Surama Manjari, State of Odisha versus Surama.
Anyway, he will be doing something.
But Surama Manjari is already upset with the Supreme Court.
That has been confirmed, my lord. In other cases, after 10 years,
Relying upon Surama Manjari, thousands of cases were disposed of. And almost many cases are remanded now.
but here, my lord,
To
after
this court.
10 years. 10 years after, my lord. The threat of contempt.
We'll have that.
Next week, yes.
Yes, next week at the request of learned DG, Mr. G. Yes.
I'm for the, my Bakara.
You file your color.
Mine.
You file it in the office.
Mine.
Whether a stamping is done, whether rightly names are written, dates are written,
Mine.
the registry will do it.
Mine.
This is not registry. Yes.
Item 12.
10 and 11.
10/11.
My lord, I am for the petitioner. This writ petition is filed challenging the order passed in ON number 18 of 2019 passed by the Honorable CAT, Cuttack Bench, Cuttack. My lord, I have instructions that the petitions are taking steps to implement the impugned order.
Implement the impugned order.
My lord,
Why have you challenged that?
my lord, after challenging, they have taken steps for implementation.
Withdraw it.
Yes, then make out a case. Argue. No,
If they're implementing.
They want to implement it. Union of India. You are for Union of India.
My lord.
You want to implement it. Their mind after filing petition. Then you don't press this matter.
That's what I'm saying. Why are you pressing it?
If you are implementing,
And implementing, my lord, my fix another date, my lord.
Why should it be pending? If you got the instruction that the order which you are challenging, you are going to implement it, this the challenge is useless. You simply withdraw it, or we will record that your statement and dispose it up.
My lord, the contempt petition is pending.
Therefore, we will dispose it up.
for the effect of contempt.
Is that the case that because of the contempt you are doing it?
My lord, pursuant to the order of the in the order.
Then why are you not?
My lord,
Under the threat of contempt, you have to comply. That's what you are saying.
my lord, in the order it was directed to held a special examination for the petitioner, and the date is fixed, my lord. The petitions have already taken steps to conduct the special examination, and it will be held on 23 of January 2026.
Then why when petition does not survive? If you are implementing that order, it liberal, or if you is it your stand that we implement because of the threat of contempt and subject to the result of petition? No. You want to implement that order. That's all. Then we will record your submission, as brother said. We will dispose of the petition.
Only one adjournment.
One adjournment. Next week you will do that. Next week. That's correct.
See the direction. See the direction. Come to page 30. First of all, why are you filing these kind of cases? 30. First direction. 30. First annexure 1. Annexure 1. No, which I don't know. This is it's a consequence of direction. Yes, first direction. Yes, the first direction. Yes, that because that. No, 30. Because that. This one. No, first direction. Let's see. First direction is A. The respondent, competent authority, hereby directed special examination for the applicant for promotion to the court of the period. 60 days. And they are holding examinations. As simple as that. And all other are consequential direction.
My lord, we're going to conduct the examination.
Yes. Then we'll record that.
Record it and finish it.
One adjournment.
What for? How much time you are spending?
First of all, we should not have interfered in this kind of orders. You are filing it, wasting time of the court. Now you are complying it.
You have said that you are complying that order, no? Then the petition does not become infructuous. Learned CGC appearing for the petitioner twice submitted before the court of court that the impugned order of the CAT for conducting subject LDCE examination would be implemented. First off, it is not his case that it is implemented. It is being implemented subject to outcome of the petition. First off. Next one, in the above circumstances, nothing survives for consideration in the petition, and accordingly, the same is disposed.
Keep on 23. 60 days time of matrix. They haven't done it. 2 years. When you continue to file, then they do.
Yes.
Item 13 has been adjourned. Item 14.
No, item 13 is mine, my lord. I am the petitioner, my lord.
Somebody mentioned it.
No. Somebody wrongly mentioned because we both are here, my lord.
Both you are here.
Yes.
Yes, Father. Argue.
That first amendment petition, that is 22412, the filed petition for amendment of the writ petition.
What is the writ petition?
My lord, writ petition is challenging the order of ombudsman, my lord.
Ombudsman.
Elected ombudsman. And my lord, so far, after disposal of the ombudsman case, my lord, the petitioner filed a petition for review, praying for not to discount the power supply.
Review. So the ombudsman has got power to review.
No, my lord.
No power.
No power. But petition is filed, my lord. This is not the prayer should not have been made like this. Once the case is finally disposed of, my lord, of the some other person or personally he was conducting the case, he filed a petition directing the distribution licensee not to discount power supply. That is meaningless, my lord. That is also not maintainable. And subsequently, when he filed the petition, my lord, on 30/3/2024, my lord, on the same day, power supply was disconnected. Therefore, he withdrew the
petition,
review petition, my lord. And so far, the main order is concerned, my lord. That is impugned order, dismissing the CR cases, consumer representation case, that is, my lord, case number 15/23 and by answer 10, my lord. In the ground of jurisdiction, my lord. That order has been challenged before your lordship.
He has no jurisdiction.
My lord?
He says
that I have no jurisdiction.
What is
against that, my lord, I have come And my lord, so far the factual aspects are concerned, I have forgotten to bring this fact that refiling of a review petition and subsequent withdrawal. This fact I want to bring on record, my lord. This is the amendment, my lord, I have sought for. Amendment is simple and it will not change the nature and the character. And my lord, another case of subsequent I have filed for amendment of the prior portion. That is 118 of 2026.
Prayer is what?
Prior, my lord, that challenging that ombudsman order, my lord, I have taken the stand in the body of the petition, but only annexure, by the annexure 10 I have omitted.
The order is produced at annexure 10.
Yes.
That you have not stated.
Yes, annexure 10 I have forgotten to mention it in the prayer.
No problem. It is understandable that you have challenged that order.
Yes, yes. And in the classic term also I have stated that challenging the order dated 18/3/2024 passed in CR case. No?
Let us see what your friend says.
There are two amendment applications. One is at flag C, one is at flag B and D. So far as D is concerned, your lordship has this formality. So far as the first amendment is concerned, that is of importance and I have filed an objection. The reason is, it is a proceeding for theft of electricity. So a proceeding under 126 of the Electricity Act commenced. 126 of the Electricity Act, which says provisional, the assessment proceeding for unauthorized use of electricity. Notice was issued, he replied, opportunity of hearing was given, a final assessment order under 126 was passed. Now that order is appealable under section 127 of the Act, but there is a pre-deposit condition. He did not make that appeal. Instead, he approached the learned GRF, which does not have jurisdiction to entertain those kind of litigations. Now, the learned GRF disposed of granting him liberty that you have an appellate forum under 127, so you allege. Instead of approaching the appellate forum to avoid the pre-deposit, he went before the ombudsman, who is the higher forum of the GRF. Before the ombudsman, he filed an interim application that my unit is disconnected, you passed an interim order. The ombudsman said, subject to deposit of 25 some odd lakhs malats, the prima facie the interim order was passed, he made the deposit, electricity was restored. Now in the final hearing, the ombudsman held that even when the GRF does not have jurisdiction, I am constituted under the same act, therefore I do not have jurisdiction. Now the line got disconnected. The ombudsman also granted him liberty to file an appeal condoning the delay and protected also that
whether there is any waiver provision.
Yes, what has happened? No, so far statutory there is no waiver.
There is no waiver.
But what has happened? Then he filed an application before the ombudsman that I have deposited 25 lakhs. The remaining amount of pre-deposit, the balance amount, is getting a bit high. At present, I am not in a position to deposit. So you grant me some time so that I can make the balance amount and go in appeal. Then he filed an application that was allowed. That was allowed. He was given some time. He exercised that benefit. Then he filed a review petition to the review of the order of the ombudsman. That was a memo was filed in the review that I want to withdraw the review to approach the appeal under 127. These subsequent developments were suppressed in the writ petition. That he filed a memo undertaking to file a appeal there. I objected on the date of listing that this particular fact goes to the root of the matter.
He could not have suppressed.
Therefore, he made a submission that I will bring those record by of an amendment. That was the first amendment, which I am objecting on the ground.
We have understood the case. You agreed that he can work out his remedy before the under section 127. Okay, let him work out that remedy. You are agreeable to that purpose?
Yes.
No, Lord, me kindly appreciate for the moment.
No, see, you have been avoiding pre-deposit.
No, I am not avoiding, Lord.
That's the reason.
Lord, I am not avoiding, Lord.
Now,
Lord, I am a MI consumer, middle industrial consumer, medium industry consumer.
Why we should entertain your petition? We are pointing out that there is a statutory.
No, because they have not followed the provisions of 126. Therefore, they have taken action under 135, Milord. 135 is the offence of theft, triable by the special court constituted under section 154 of the Electricity Act.
Two things.
And
one second,
Milord.
covered by the judgment.
Yes.
One, for recovery of the amount payable for having the power is one thing.
Yes.
It is a criminal offence is another.
Yes, Milord.
They can do both.
My lord. Your lordship may appreciate section 154 of the Illicit Act.
But why have you,
My lord, I am coming to that. my lord.
why have you said while withdrawing your review petition that I have
He filed a-
night once, thrice you have said.
My lord, he
like that.
filed it is not my change, my lord. I have agreed with the main order. Review petition, though not maintainable, he filed a review petition praying for extension of time, my lord, not to discount power supply. That is also not required or not the proper
And
appropriate
you
plan.
an IA also saying that the
No IA was filed, my lord. And that petition which was filed for review on the day of presentation, since line was disconnected, he withdrew that, my lord. And withdrawal is allowed, my lord. After disposal of the main
You
case.
said in that, that's what he said. You said in that you are going to invoke section 127.
everywhere he is saying.
My lord, 127 is barred by time.
Therefore,
I am bringing to your lordship's notice, my lord. My lord,
it is barred by time.
barred by time.
It's over.
Barred by law of limitation, my lord.
Yes. Therefore, no writ is maintainable.
No, read no.
Huh.
My lord, when where they say that we have passed final assessment order, that is barred by law of limitation as per section regulation 165 of the Illicit Act.
Correct.
I will bring to your lordship notice.
So
to
what
that.
we should do?
My lord,
If it is barred by limitation,
yes.
the cause of action dies.
Yes.
Then you cannot maintain the writ petition.
No, writ petition. No writ petition, my lord. Why I am pressing the fact, my lord, your lordship will take the decision. Lordship have a glance to regulation 165.
Now, what is that order you have challenged? Let us read the order itself.
My lord, order is annexure 10, my lord. No, we will go to that, my lord.
Annexure 10.
My lord, annexure 10 is the order of ombudsman.
Page number?
Page number, my lord, 44 starts and it ends with page 47, my lord.
47.
My lord. Last line, my lord, hence the order of closure of this proceeding with observation of a lack of jurisdiction is pronounced, my lord. My lord, what happened, the factual aspects.
You asked us to read it, we are reading. Wait. The provisional order is dated what?
My lord, provisional order is at page, my lord may see, that is,
Page 13, Mal.
We are not asking page. We are asking date of the order.
7/10/2022.
710. 710 is the verification and 710 is the provisional assessment order.
7/10/22.
Yes, Lord.
And the final order is
Final assessment order.
2/11/2022.
provisional order is Annexure A1.
Provisional order is Annexure 1 series.
Annexure 1.
My lord.
And now final order is dated
11/1/2023.
No. Final assessment order
They
is
have
2.
My lord, what happened, what fraud they have committed, I will bring to your notice, my lord.
afterwards you can argue. Give the dates first.
Yes.
Final assessment order is 2/11/2022.
27.
Page 27, your lord's right.
Next.
Annexure 4 series.
Page 27, running page 27.
You had challenged that you had challenged only the provisional order.
My lord, what
We are
happened?
asking
My lord,
to know that we are asking you. We will not answer.
yes.
You should be kind to the judge.
Provisional assessment order I have challenged.
Provisional or final?
Provisional.
Provisional order.
Why I have challenged?
I am not asking.
I approached the GRF.
We are not asking that. We want to know.
Yes.
You have to treat the judges
Yes.
with love and affection.
Well, it is provisional. When it is become null and void, then I approach the GRF. Lord's my kind appreciate for the moment.
Permit us to process the matter also.
I am sorry.
This is
I am sorry.
you know the facts. We need to know the facts. Then
Milord.
we can decide.
Sorry.
We are asking clarification of facts only, I will satisfy.
Advocacy. You had challenged an order dated 7/10/2022. Is it right or no? Say binary answer. Thereafter you can explain.
710, my lord.
Correct?
Yes, my lord.
He has to agree with us, man.
No.
What you had, we are asking.
What I have challenged, I will say.
You have to resist your temptation to argue. You should answer the questions of the court. We are asking you.
My lord.
Did you challenge the provisional order dated 7/10/2022? Yes or no? It does not admit anything. It's a binary answer.
My lord,
You can explain.
My lord, I have challenged before the GRA.
That's what I am asking you. And when the matter was taken up, the final order came to be passed on 2/11/2022.
My lord, they have said that we have passed it 2022.
Correct.
My lord, the law provides.
No, we are not on that now. We have to ascertain the facts. You can jump.
My lord, that is the fact I am trying to bring to your lordships.
No, not necessary. Step by step, we have to structure the judgment.
Yes. Yes, my
For
lord.
that, just tell us the facts. You did not challenge the order dated 2/11/2022. We are asking you.
My lord.
You have not. Whether a provisional order would merge into the final order? We are asking you.
When the provisional assessment order has become null and void, the question of merge with the final assessment order does not arise. This is my submission.
No, 1 second.
No, you have declared yourself that
No, as per law, I will take to my lord's attention to section regulation 165. My lord, see.
No, facts you have to assert.
My lord, facts, sir, it is a fact, my lord.
Better that you will argue this matter before some other bench.
Well, I thought my lords will have.
Then you have to answer the court's
My lord.
patiently,
My lord.
resisting the temptation.
sir, we will allow you to argue.
You
Let us be clear about facts.
My lord.
That's what our anxiety is.
In the
Let us
law,
understand the fact.
that's in the law, legally speaking, it may not be applicable to you. Just we want to ascertain whether the provisional order merges into final order or not. Forget this case. We are asking you a question of law. Whether this provisional order would merge into final order or not.
My lord, it would be more than the final assessment order, provided the final assessment order is passed within 30 days from the date of a provisional assessment order.
There is a limitation for passing the final order.
Yes, my lord. Your 26(3), lordship.
Which is that?
Section 126(3).
Please.
Lordship's attention may be drawn to section 126(3) of the
Is it legally correct?
Electricity Act 2003.
This 30 days.
30 days.
Suppose if within 30 days, for example, CPC says application for injunction should be disposed of within 30 days. After 30 days, you mean to say the court has no power to pass order at all?
No, court,
how it is structured?
Court has power, my lord.
Let us.
But when the section says that final assessment order should be passed within 30 days from the date of a service of the order of a provisional assessment. Here, my lord, admittedly, provisional assessment order was served on 7.
All right. Whether this order, regulation, is it regulation?
Yes,
What is that regulation?
It is act, my lord. Act and a regulation are said, my lord. In consonance, regulation 1.
You are a confusion master, perhaps.
No, I am.
We are asking you, is it the regulation?
Yes.
Yes. Which is that regulation?
165 of OERC distribution conditions of supply code 2019.
All right. Whether this regulation is central legislation?
In consonance with the Electricity Act, section 120.
Not answer that again. Confusion master it. Is it promulgated by the central government? Where promulgated?
It is Orissa Electricity Regulatory Commission.
Village 162 is spent period of application or making of the law. After the expiry of the stage we mean to say the authority has no power to pass the final.
Yes, ma'am.
Yes.
Yes.
Any change?
My lord. Judgment is there, my lord. My lord, Sitaram rice mill case. My lord.
Okay, whether that sanction is mandated, the regulation is mandated.
Yes. Yes.
Ordinarily, TPC says the law prescribing period for passing of orders in restitution proceedings
My lord.
are not treated as mandated.
Yes.
What is the process?
My lord. My lord, here. So, Sitaram rice mill case is concerned, my lord. Your lordship, this honorable court, relying the Sitaram rice mill case, my lord.
You can take up all the contentions before the appellate authority.
No, my lord, once the demand is null and void, I will put on Sri Bodhan, my lord. My lord, what happened in this case? My lord.
Is even our question is answered with the apex court against you. Take out that judgment. Referring to wait and proceed. The opposed to say, even if it is a nullity, still it exists in the eye of law. I will be able to challenge it before the impropriety proceeding.
Appropriate proceeding, my lord. I agree with my lord. My lord, what happened? What illegalities they have committed? First of all, they have not granted me an opportunity of hearing to the provisional assessment order. Even, my lord, even if the yes, my lord, I am bound to hear, my lord.
You are bound to hear. Now you are bound to read that.
My lord.
Read.
My lord. My lord, may I?
1990, yes. Page 21, paragraph 567. Sorry. The other judgment.
Well, let's.
And he replied to that. And the person within 7 days, thereafter, any person served with the passion, thereafter 5 days. Then what the only way into that.
He is saying since it is honest, you can challenge it wherever something wants to say. That I am counting by the Supreme Court judgment.
My lord, I will go through that, my lord. But one thing I may brought to your my lord, my prayer is I was not given an opportunity hearing to the
that you can take up the appeal.
Final assessment order. That is, my lord. So thirdly, my lord, the order is without jurisdiction. The person who has passed the final assessment order, he was not present during the verification of installations. Since he has seen nothing.
Why are you shying away to approach the appellate court? That's the question. You have a very good case, no doubt about it. But before the authority, before the right authority,
what they have done, my lord, suppose I would have been imposed a penalty of rupees 1 lakh, they have imposed it 1 crore me. Because my contract demand is 79 kilowatt, my lord, they have made some wrong calculations by calculating the idle machines which were kept inside my premises, my lord. They have done it to 149 kilowatt. Right. So they have brought it into my large industry fold, my lord.
Apex court say, right of appeal is the creature of law, and law can condition that right. Where right of appeal is given to you, subject to complying the condition, Apex court says you have to comply with the conditions unless the appellate authority has power to relax those conditions. That was under section 17 and 19 of the Surface Act. The date of that is Dr. Vijay Mallya versus State Bank of India. Where apex court, a division in judgment of Karnataka High Court affirmed by the Supreme Court, where law, right of appeal is given to you by law. Right of law, appeal is a creature of law. It has to arise from the statute. I will state the Bank of India versus Dr. Vijay Mallya. You say question of the right of appeal is conditional. That condition you have to comply. That's the most what we can do is, you can make an application for relaxation of the condition of pre-deposit. There is no provider for relaxing.
That's the whole problem.
There is no provision.
There's no provision.
We have understood your case.
Had there been a proviso to 127.2, we could have done it. There is no proviso to that effect.
Yes. Milord,
Either it's full or half. Not less than 2.
Milord, from the date of provisional assessment order, I have a right to prefer appeal 122nd.
Not from the date of original assessment.
Final assessment. Milord, what happened? For the facts, I will be satisfied with what you will hear for the moment. Milord, on 1710, they have passed the provisional assessment order. They did not pass any final assessment order. Then I approached the GRF, taking the ground that since the provisional assessment order was not passed and served on me under 126, the demand as raised by them is null and void. Milord, I approached the GRF. Milord, GRF, without registering my case, complaint, GRF has issued me a communication that they have passed the final assessment order on that 211. And that was communicated to me, Milord, after 4 months. And nowhere they have said that it is served on me. That has not yet been served on me. GRF has communicated the same. Milord, if it would have been communicated to me in the appropriate time, Milord, I would have preferred appeal. I would have been given an opportunity of hearing, Milord.
We will give you time.
That your Lordship will give. Then when the GRF did not...
We will give you a reasonable time to prefer the appeal.
That is all right, Milord. Milord, our Chief Honorable Court, when there is procedural irregularities on the part of the licensee, Milord, the GRF was approached. That order was challenged, Milord, on behalf of the TPCODL when I was the counsel, Milord, and my learned friend was the counsel for some other counsel, Milord. This Honorable Court has held, Milord, that is the WPC number. Milord,
in this case, the provisional assessment order is confirmed in the final order. That's all.
Milord, in that case, Milord, this Honorable Court division bench, coordinate bench, Milord, has held that GRF has power when there is procedural irregularity. GRF has power to
power against what? Final order.
No, against the dispute raised with relating to that not following the due process of law by the licensee 126, due process as enumerated under section 126. 126 prescribes that as soon as the provisional assessment order is passed, consumer is to file an objection, and after giving due opportunity of hearing to the parties concerned, Milord, they will pass a final order within 30 days. And many things are to be written in the final assessment order, what he has stated in his objection, what he has submitted during the hearing. Taking all those facts, he will pass a reasoned order to the best of his judgment. Here, Milord, that has not been done. And simply, when I approached the GRF, they have communicated this, that we have passed this order under 1 section 35. Milord, 1 section 35 is the offense under 135. 35 is the offense theft of electricity. It is to be tried in special court. And 154(5) says that the special court will decide the liability, decides the penalty aspect, so far the theft of offense is concerned, Milord. What quantity of theft electricity, I have committed theft. That is the special court will decide, my lord. They cannot take recourse to section 135 because it is within the domain of that special court. And the notice lords may see, that the GRF which has communicated to me, my lord, that is under section 135. They have, GRF has said it is under 135, my lord. Lords may see that page, Lords may see 127. Lords may see 127.
27.
Final assessment orders.
So you've seen it. We have seen it now.
You are harping up in the last line of the second paragraph. Last line of the second paragraph.
No.
You are saying
On the top
3
of
months from the date of the physical verification, which is not acceptable as the provisions under section 135 of Electricity Act. That's what you are harping upon.
No, yes, the 135 they have said, and on the top of the order of a final assessment order section 135. When the order was not passed under section 126, my lord, 127 appeal, perhaps, my lord, it is not maintainable, and the appellate authority also.
What he is trying to say is, you have not at all passed the final order, which was supposed to have been passed within 30 days. Because the page 27 final order, which you are designating, that is an order under 135. It is a death provision. So therefore, since there is no final order passed in my case, there is no question of filing 127 appeal. That's what his case is. How will you answer to this? Page 27. Is it a final order under 126 or 135? Answer it, that's all. We will not go further.
In order to
Provisional order.
Regulation says, my lord,
113.
is
13.
there's a
Come to 1.3.
that's 1.3 of the writ petition.
Yes, provisional order.
Provisional order asking him to show cause. This is referable to 126.3. 126.3.
Yes.
Where have you stated 126.3?
and on the top 135 they have written, section 135.
Now, what section they write is irrelevant. If content of the order makes it a particular provision. Wrong quoting of provision will not make it the order under that provision. Law is settled with that regards.
Page 13, it is said that notice to show cause of provisional assessment.
So provisional assessment is done under 126.3.
126.3.
Regardless of what section you have quoted, it is a provisional order is your submission.
And Malaks,
And come to 127 now. Come to 127. We come to that.
Section 1.
No. Page 127.
27.
The wrong quoting of the provision.
27. Only 27.
In response to your so-called notice dated 21/10/2022, you have given the so-called notice reply.
Yes.
It is found that the reply number so all these things within 3 months verification and everything. This is 126 only.
The entire
126.5.
The entire
Wrongly quoted.
135 is wrongly quoted. 135 is wrongly quoted. It is essentially 126.5 or
Because you have
replied to that.
replied. Just see.
You have sent the reply.
Yes, I'll show you the page also.
There was a clarificatory.
My lord, they must have given a reasonable opportunity of hearing to me. I could have placed all those things, my lord. My provisional assessment would have been reduced
It is a ground for
to
challenging final order.
Page 18, just see your reply
my lord.
under 126.4.
Yes.
Passive reply.
Yes.
Then you knew there is a provisional order.
Yes.
You reply to that.
Well, I replied that.
26.4.
I declared that.
Right? 126.4 is complied and 126.5 is a consequential order which was final order passed. That is page 27.
My lord, they did not give me an opportunity of hearing.
That can be a ground for challenging it.
Yes, no final assessment was
That
passed,
ground you can
including
take
that.
up in appeal,
My lord.
not before us.
My lord.
You file appeal. We'll give you time. You file appeal.
No, that so far 165 regulation is concerned, my lord.
But
When
we
the,
don't
when the
agree with your
demand is not null and void, my lord.
That can be a ground for appeal also. You can place it to service, regulation 165. That also can be.
We are also
Yes, your lord. What problem is that, my lord?
Final order
In place of lesser amount, they have arbitrarily done it, for which I could not meet the.
That can be a ground for appeal. all contentions you are urging before us can be the contentions in appeal.
Yes, my lord, that be the contentions, my lord.
Why we should be, it's a special act. Special machinery is provided. Parliament knows who should decide what. We cannot simply appeal over the wisdom of Parliament.
Not of.
Because you are not
that,
challenged this section.
because there are certain lacunas and they have not followed. I have not given an opportunity of hearing where the alternative remedies there, my lord, or it is maintainable. Whirlpool Corporation case, my lord, Lordship knows that it is maintainable. All right, I will go through this judgment as my lord cited.
Nothing.
My lord, it will come some next week.
No.
My lord, I will go through that judgment. My
No,
lord,
we are not
for my own
that judgment.
for my satisfaction. my
We
lord.
are not referring to that judgment. We are not here to, we are not undertaken the educational campaign in law. We are here to adjudicate the matter. It was only by way of concession to confront to you.
My lord, what I submit, my lord. I am without electricity since last 5 to 10 months. My lord, initially I was in that.
All that you said.
By order of ombudsman, when the ombudsman had said he has no power, he directed me to deposit 25 lakhs. By making a loan and borrowing hand loan from my friends' relations with much difficulty, the petitioner deposited 25 lakhs. My lord. When by order of the ombudsman I have deposited, the ombudsman did not exercise.
Factored into 25 lakh which you have paid, that will be factored into the pre-deposit condition.
No, that
we can say
I
that.
know, my lord. That I know, my lord. When they have done it in the higher side, my lord, it must be reduced to some lower amount, my lord.
That is why there is a appeal provision. If it is higher or lower, the appellate court will decide what to do.
And so far I have delayed.
50% you cannot.
My lord,
Full amount or 50% of the amount.
50%.
That is the power given
50%.
by the Parliament has given. It's an injunction by the Parliament. You want us to violate that injunction without challenging that section?
No.
You're answering the
Or you have any judgment?
And my lord, my
judgment goes against you.
my lord,
Ruling goes against you. With Dr. Vijay Mallya was so and so.
my lord,
The expert said, where precondition of depositing is made by the Parliament, no court can relax it unless that.
no, I am not praying for relaxation, my lord. But if I would have been, they would have followed proper process of law, my lord. My lord, if they could have followed process of law, they could have given an opportunity of hearing to me.
All these
I
things
could
again, sir, don't repeat.
And I could have, the amount would have been
These are the
reduced,
grounds available.
and ultimately I could have got a chance of.
Dismission begins to follow. Yes.
Item
My lord, lordship may give another date, my lord.
No.
My lord, I will.
Otherwise, unless you have to play like this.
Well, I am not playing, my lord. Lordship may kindly. I beg pardon for that, my lord. I am.
We have heard you enough. This is a 227 petition, not 226. You need not be much heard also.
My lord, your lordship may, with that liberty to prefer appeal, my lord. Your lordship may ask the order granting us liberty, my lord, to file appeal within a month, my lord, or within 2-3 months, my lord, because I am to meet the demand, my lord, and all those grounds.
Now, petition reads as an learned counsel for the petitioner, having argued the matter at length, considerable length, now submits that he is going to be given liberty to file statutory appeal under section 127, correct, of the Electricity Act 2003. And to facilitate filing of such appeal,
Against that,
a reasonable period is granted. Brother, that we have to.
that against that final assessment order, which is at a phase.
The final assessment order dated 2/11/2022, passed under section 126(5).
Well, that served on date may mention. That served on was on.
Allegedly served on the petitioner.
11/1/2023.
We are saying we do not know. As you said, we are saying.
Yes, my lord, it is there. The JRF has noted that also. On 11/1/2023.
Legislative Sargam 1/11/2025.
No, 23.
23. First, with the above proposal, the panel counsel appearing for the OPs is agreeable. Very fair. First, next one. In the above circumstances, petition is disposed of with the liberty to file the appeal within a period of 8 weeks.
Lords may say 2 months because I am to arrange count me not. It is
8
weeks.
Within a period of
3 months within that I can, if earlier I could arrange, I could go within.
First, if the appeal is filed within the said period, the ground of delay and laches would not arise. First, all contentions of the parties are capital. First, next, it is open to the petitioner to urge all the contentions that have been taken up in the petition hearing. So is the case with the OPs.
One prayer, Lord, I may be given a liberty to deposit the amount in shape of.
No, that you have to ask their But we will say whatever amount you have deposited, that may be given set off in pre-deposit condition. Next time. Whatever amount the petitioner has deposited before the
OP pursuant to the order of the ombudsman.
Before the
opposite party, present opposite party.
OP number 2 shall be given discount
Pursuant to the order of ombudsman.
Adjusted.
Adjusted.
OP number 2 pursuant to the order of the ombudsman shall be given discount in computing the pre-deposit amount
Statutory.
under the provisions of Section 127.
Yes.
127. First. The submission of counsel for the petitioner that is the amount is very high and therefore installmental facility should be granted is kept open for being urged before the authority. Appellate authority. All.
Item 14.
Yeah.
Item 14.
My lord, I preferred adjournment. Actually, in another matter, copy was not served upon the council, so I am sorry.
You want to give copy to them?
One matter I had already solved.
Second Sobatum, I have already entered my appearance. Since 22nd December 2025, my name is not appearing in the list.
We just need to print the name of the council as appearing for the sole OPs.
Sole OP.
Sole OP in WP number
37101.
the item, call after 2 weeks at the request of. Yes.
Item 15.
Small matter couldn't dispose today. Only issue involved whether the vigilance officer can be the inquiry officer or not. Your lordship on the last token asked me, I have supplied the citation. Expect that taking time.
You supply the same citation to him.
They
It's covered by the judgment.
yes, madam. You know, India versus Prakash.
Next week we will do that.
Smile.
Problem. Yeah.
Item 15.
Where please, securitization
What are you seeking? What is your prayer?
I am only seeking that the opposite party number bank may entertain the petitioner to explore the possibility for one-time settlement or negotiation refacement to clear the loan amount, because the petitioner is victimized by the act of opposite party number.
Already that you are the liability of the surety.
Yes.
Is coextensive with that
Yes,
of
my
the
lord.
principal borrower.
Yes, my lord.
Whatever they can proceed against you, or they may proceed against the principal borrower.
My lord. My lord, because of the opposite party number 4, the petitioner who is a senior citizen, he has also approached the designated court regarding maintenance and welfare.
The petition is maintainable, brother.
My lord, I only prayer, my lord, my opposite party number 4, consider my representation.
You are making prayer in a wrong place. You are making prayer in a wrong place. You have to make the same prayer with bank people.
My lord, I have approached
Not
the
in the
bank,
court.
but they have not entertained. That is why my request to
You can't compel
entertain.
them.
We can't force them.
OTS is a contract. OTSC
My lord,
an offer.
my lord,
Is it not?
my lord.
Can we compel the other side to accept the offer?
Not
That
only, my
runs
lord.
contrary to the foundations of law of
Yes,
contract.
yes, my lord. Not only, yes, my lord, only if the permissible refacement or getting time to raise the money to clear
The
the.
best way is withdraw with the liberty to approach the bank.
My lord,
That's all.
my lord.
Petitioner has
My appearance for the bank mechanism.
Huh?
My appearance for the bank.
Having argued the matter for some time, seeks leave of the court to withdraw the petition with liberty to approach the bank
My lord,
with OTS offer.
Okay, this will help you.
my lord.
Instead of arguing, go on to it.
Do you have objection for the withdrawal?
No.
Learned counsel, panel counsel, appearing for the bank very fairly signifies his consent to withdraw. First, next, in the above circumstances, petition is disposed of with liberty as sought for.
Okay.
And you do all preliminary work.
Ah.
Let's take your friend, give a cup of coffee, preliminary work you do, and then.
Yes.
Item 16.
Yes.
I am for the petitioner actually in this matter. Yesterday actually my lord have. Now audible, my lord? Is audible now?
Yes.
I am for the petitioner, madam. Actually, yesterday my lords have given a suggestion actually because there is already a pending case before the DRT, whether he can, that is by his brother, whether he can be imputed thereon without going through the separate case. That actually yesterday I had, my lords have suggested, I agree to that proposal actually. But that should not be a new case. That is the only problem.
Yes, yes. Essay number?
Essay number.
Earlier it is 71 of 17 years.
Which is pending. Your brother has filed that.
Another one.
Pending.
Brother.
Permit you to go and get yourself in detail. That's all.
But your lordship has the other day, the subject to lord's permission. My lord has put a question to Lord friend Mr. Pradhan regarding order 43 rule 1A. And also alternative suggestion to me. But he says, yes.
See, what will happen is, you are right. What my brother has asked the legal question that can be done. But why there will be a parallel proceeding? Your brother is following one proceeding and you are following another proceeding.
No, man,
3 rounds.
that's right, madam. You lordship, I agree.
Let it be.
But one moment.
Opposite decide to one.
It is decided for all and it will bind him also.
And he is agreeing to
I
that.
agree with
You
my
won't let him get implemented.
I agree with my Justice MISHRA and all this, my lord. I am not deciding with that proposal. Only bring to anxiety my because I have gone through my lord's judgment. Yes, the lordship has taken so much strenuous effort and by the research assistant and giving the judgment. Your lordship hold that the Limitation Act is not applicable. Even though the facts of that case,
That is My lordship,
Your Lordship,
the Karnataka,
in the Karnataka High Court.
in Orissa High Court,
Odisha High Court, there I
I have
have
another role.
My Lord.
We don't want to take pain of writing.
No, no, sir. I don't know why.
After he concedes, after he concedes, we don't want to take pain.
My Lord, because I am always happy that
Academically, that is a question to be answered in the right appropriate form.
Yes,
But
sir.
now he is conceding.
I agree with my Lord Justice Mishra, when he was practicing the Supreme Court, when appearing with him, in some cases I appeared, he has a head अरे यार जल्दी खत्म करो उसको.
So that's what we say.
Judges को खत्म मत करो.
नहीं.
Judges also.
My Lord, what happened, my Lordship? One moment, for moment, kind of what is
Petition
happening?
here reached as under. First up. Learned counsel appearing for the which OP?
Office partner one, my Lord.
OP number 1.
And for 2 to 4 minutes.
In 1. And learned advocate appearing for OP numbers
2 to 4 minutes.
2 to 4. Vehemently opposed the petition prayer. Placing reliance
I am not-
on a division bench decision of Karnataka in
I'm not opposing the prayer of the petitioner.
Thank you.
You are not okay.
I am my Lord.
Placing reliance on a decision of a division bench decision of Karnataka High Court
My Lord,
in
sorry, my Lord, I not some sort of nature.
Karnataka Bank Limited 2025 SCC online Karnataka 16631. Next one. At this stage, learned counsel appearing for the petitioner, the case. And we agree with the same that the liberty should be leave to withdraw the petition should be accorded with liberty to the petitioner.
No, this is auction purchase the
Yes,
petition.
he is challenging. No, you will not press this petition.
I am not I am the OP number 1. I am the borrower. My Lord friend is auction purchaser. He has challenged the DRT and DRT order. I am condoning the delay.
Condoning the delay.
I on the ground that
1 minute. He went to the judge. He immediately. Let him go and include in the proceeding.
You are the principal borrower.
no, I am petitioner assisting Mr. Pad.
You are petitioner.
I'm the auction purchaser.
That's all.
Auction.
There are two brothers.
Brothers.
Two brothers. One brother is preventing the auction process in right proceeding, and he resorting to this.
Both of them are borrowers, man. Actually, both of them are joint borrowers.
You will go before the in essay.
No,
He will get.
they have already met
My lord says
Pending essay.
it's your brother's essay.
Yes.
his brother,
Your brother's essay.
my
Oh,
brother has filed this.
Lordship,
Lordship filed this.
Over.
I wherein I am
There also it was also amended and auction sale notice was also challenged. And in this case, I was issued notice, Lordship. In his brother.
What to do notice about what? Yes, the fully co-borrower, the brother of two also different. Brother of two, fully co-borrower.
Yes.
From the, after hearing both the parties, it came to the notice of this court that the co-borrower, what is his name? Co-borrower, the Bikram Kishari Vinod, who is the real brother of opposite party number 2.
One lord.
Opposite party number 2.
has already resorted to the proceeding before the debt recovery tribunal by filing essay number 71 of 2017. The opposite party number 1 on the proposition fell from the court, which was agreed by the petitioner, conceded to the position and submits that if permission is granted to him to get him included in the pending essay, he would not further prosecute the present proceedings. The counsel for the petitioner has no objection to the same. In view of the same, permission is granted to the opposite party number 1 to get him included in the pending proceedings before the DRT in essay number 71 of 2017. In that view of the matter, the present proceedings need not be adjudicated upon, and quietus could be given to the present proceeding. Quietus could be given to the present proceeding. This being a consent order, we dispose of the present petition. This present petition is disposed of by the present consent order. Why do you have the consent order? Of the parties, consent of the party.
One request. That is already says, Lordship, essay number 132, 2002.
134, essay number 71.
In that case, they will be pleaded, but in
This essay will be not transposed.
But the Lordship, that not be placed separately, but the pleadings taken there, that will be taken part of the hearing.
In view of the above, the opposite party number 1 has agreed that the essay number 135, initiated by him, he will withdraw the same and rather pursue his remedy through the essay number 71 of 2000.
One suggestion.
You withdraw it.
One suggestion, my lord. The Lordship and one line observation are not necessary to file further pleadings. Because that pleadings have advanced in that essay, that will be treated as a part of this.
The pleading thing we will decide.
Otherwise, my Lordship, what you request, Lordship, the Lordship can see the predicament of a loanee. Because no doubt, Lordship, I am brother. But my position has equal 50% right over the property. Then I may be permitted to grant liberty to file my statement of claim.
See, you can make those
implement and pleadings.
Once you become a party, automatically you have to be given.
Unless I amend the matter of the pleadings of my stand.
We will see what
will prejudice in that. And both the orders, Lordship, may be settled. The TRT order as well as the appellate court order.
We were putting in a quietus to it. We are not saying, we are not adjudicating at all. We are not adjudicating at all.
Personal and that of the liberty to me, my lord, to implement.
Will state correction, we'll do it. Yes.
Well, because that he has to, unless he is give the statement.
My presence for placement.
Even writing.
So placement.
We will get a rebut.
Personal, so that I can run my industry and to meet the.
It is open to the petitioner to review his prayer for restoration of power supply in accordance with law. You will not say anything beyond that.
Before the upper letter.
It is open for you to move application.
Yes, that obligation person.
But I should read that Supreme Court judgment. 1992, AR 92 SC, page 111, paragraph 567, where your contentions have been thoroughly discussed and rejected. Look into that judgment. They refer to Wade's administrative law, Wade and Forsyth. AR 1992, SC, 111, paragraph 567. This state of Punjab versus Gurudev Singh. Yes.
Item 17.
Yes, sir.
I have approached this honorable court with a prayer challenging the position notice for position under Annexure 6 law. But before going to the legality of the order, I may apprise this court with facts of the case, Lordship.
Restructuring of loan account.
No, Lordship. That is for symbolic possession of my property.
No, read your prayer 3.
Lordship, prayer that has been.
You have amended the prayer.
No, Lordship. We have not amended.
This is intact.
Lordship.
You are asking for restructuring of the loan.
Lordship.
That's your petition prayer.
You are the borrower.
I'm not the borrower, Lordship. Lordship, the property is a joint family property. My father and my brother, they had taken a loan against that property. Thereafter, they
father is karta of the. Your
father is dead. Lordship.
Yeah, karta is entitled to take, na?
Lordship. Yeah. But my brother has primarily availed that loan, and he is not available with us right now because he went somewhere else and we do not know if he is dead or he is alive. So after that, I have been served with a 13-4 notice, Your Lordship. After that,
have been served or your brother?
I have been served. Then after that, I approached this honorable court and write in WPC 25833 of 2024. Lordship. After that, I gave a representation before the bank stating that I am agreeing to OTS settlement of 1,80,000 because my father and my brother had availed a loan of 7,35,831. Until 2023, they have repaid 7,69,744 rupees, more than the amount they had taken, Lordship.
The interest and other things will be there.
Lordship, they have repaid. So to show my due diligence, I have given the OTS representation. It was then, after that, I approached this honorable court, wherein the court directed the bank to consider my representation, and till the time the representation disposed of, I was protected. On 22/4/2025, Lordship, I withdraw that rate application as the bank undertook that it would consider my fresh representation. Then I gave a fresh representation on 29/7/2025, Lordship. My fresh representation is, Lordship, at Annexure 5 series, 8/4/2020. Stating that I am agreeing to deposit 70,000 and the OTS may be settled at 2,50,000, Lordship.
How bank? It's a public money.
Public money, Lordship.
Means our money.
Lordship.
So you want to take benefit of our money?
No, Lordship.
You want to put your hand in our pocket in a way, indirectly.
No, Lordship.
It's a public money.
Lordship.
And which law says that OTS should be accepted? You are not even a borrower, nor the guarantor, nor anything to do with the loan.
No, Lordship. But the property is joint family property.
That is what you are saying. We don't know. If the loan is taken on behalf of the family, there is a presumption amongst Hindus. Hindu law says
Lordship.
Every Hindu family is presumed to be a joint family, unless the contrary is shown.
Lordship.
So where father, and there is a presumption that father is the karta of the family.
Lordship.
Okay? If father has got power to alienate or encumber the family property.
Lordship.
For kutumbarte apatkale vyavaharike.
Legal necessity.
Legal necessity. If he has done that, you are bound by that.
I am bound by that. I accept that.
Where is the earlier order? Order of the High Court, this court. That you have not filed.
If that has been withdrawn, that is why
He has withdrawn that petition. Sir.
withdrawn that.
The court has given you one indulgence. I think that's enough.
Lordship, no, after that,
they have not considered my second representation, Lordship. That is my
You
sole.
can't keep on coming after give one representation, file one writ petition, get a direction, thereafter withdraw another representation, again come here.
Lordship, that
No, what is your right in connection with that loan amount? Who are you?
I'm
Where is
the
the privity of contract?
I'm the legal heir, Lordship.
Legal heir of
Father of the father.
father died.
Father died. Notice has been served directly upon me without giving any notice to the father. They have served directly upon me in 2024, Lordship. Before that, my father had been repaying. I was not aware of the loan itself.
Petitions are filed to enforce any enforceable right.
Lordship.
What right you have, you tell us.
Right.
Representation, deciding a representation.
Lordship.
You gave a representation.
Lordship.
Then you have a right to give or you don't have a right, we don't know. How can we give a direction? What right you have?
It is your
Lordship,
Enforceable right.
at Annexure 3, Lordship, I have given the ROR of the property.
All these things again.
Now, how we can decide all those things?
You
Civil court, that's all.
you withdraw with the liberty to approach the civil court.
Or DRT, whichever. We will not
Lordship,
adjudicate.
DRT, I may beg your pardon, Lordship. Lordship, if Section 17 gives the right to the borrower to approach the DRT, Lordship.
Yeah.
But
But you said you are not the borrower.
no, Lordship.
Then
Lordship, if that property is sold of Lordship, that is my house, my residential house, Lordship. If I would be shelterless, Lordship. I am staying in that house. That is there. That
you should have told your father, Father, don't enter into this transaction. That will prejudice my right of abode. That you should have said. Having allowed father to borrow money and give education, get a job for you, get a marriage, then saying that I will be thrown out from the abode.
No, Lordship, we oblige by that. We say that we are going to pay the amount, Lordship. We are not denying that, Lordship.
What is the amount? What is the amount left to be paid?
Lordship, the bank is claiming that 7 lakhs some odd. That annexure 6
months according to calculation.
The bank is claiming 7,59,309 rupees.
Pay that and retain your money, your house.
Lordship, we already paid the more than principal amount, Lordship. This is the only interest amount.
Yes, pay that.
We also ready to pay that, your Lordship. And we also withdrew that writ petition after bank assured us, Lordship, that we settle that amount. And we already deposit the upfront amount of 70,000 rupees, Lordship. Then only 1,80,000.
You withdraw this petition. Think about that. We are only putting
Lordship, kindly listen, Lordship. Lordship, that this your test is still in progress, Lordship. They don't reject it, Lordship, but they take the symbolic position. So, your Lordship, I also filed an IA, Lordship, for stay of that auction, Lordship. We still discuss with the bank to for the test proposal, Lordship. So, kindly state.
We'll simply adjourn then.
Lordship.
Process is going on then?
Yes, Lordship. Process is going on.
You have to say anything. No.
There is no police action, and otherwise, Lordship, the family of the petitioner, his elders, all of the persons are staying there, Lordship.
It happens
They are suffering a lot.
loan.
And the family was already died, Lordship. No one is there.
Many are ready. What to do? The larger world is completely full of dead
Lordship,
people.
we are ready to pay, Lordship. We are not denying the fact, Lordship. But
You
kindly give us a time.
It is meaningless because there is no prima facie privity of contract. You claim to be the LR of deceased father. We don't know. Even otherwise, if you are LR, maybe the contractual obligation will fall upon the LR to pay back the debts of the father. Vyavaharika. Okay?
Pious obligation.
Pious obligation. Whether you inherit property or not. You are bound to discharge the debts of the father. This is what Gautama Sutra says in Hindu law. Pious obligation.
The amendments of it.
That's fine. You pay that money.
Lordship will pay
that house.
But Lordship, what they have done is they have put the property for auction sale.
Therefore, you should make payment.
Lordship,
So
before
that they will not put the same to the applicant.
Lordship, they have given us the symbolic position of notice on 31st of December, given us 60 days time. But today they have given that advertisement for auction sale.
But that is simultaneously they can do that.
Lordship, but if that auction is made, we will not be able to redeem our property, Lordship.
Then go and give money immediately. Tomorrow.
Some time may be granted so that
That becomes precedent for rest of the people. We are dismissing the petition.
That's the petition.
Lordship, kindly give some time to decide the OTS, Lordship. It is in progress,
We
Lordship.
will adjourn this
Till
matter.
that time, Lordship,
Brother say-
kindly give us.
We can only help you by adjourning it
We'll
so that
adjourn this
there will
matter.
be a pressure on the bank. They may do something. Otherwise, no order can be passed.
We cannot.
It's not a mercy petition, it's a writ
We are
petition.
ready, sir, we are ready to pay, Lordship, but in the instant time, we don't.
You have to make out a case for writ petition. What is your enforceable right?
If I may not.
Deposit.
If I may.
Will you pay 50% of the
amount?
amount?
Amount.
We'll
Demand.
pay.
At least we'll examine, we'll ask them, do something.
We'll pay, Lordship. We'll pay, Lordship.
Few minutes.
Yes,
There is some urgent work.
Miss Melas might go.
Only put proceedings. Only put Yes. No. Yes. Which is the serial number that the criminal appeal? 18. Take out 18.
No, definitely it's going to be paid for offense under section 302, section 3, read with section 3(2)(v) of HCST QA Act. And sentence to life imprisonment. Admit all for TCR. And so far as the application is concerned, the application for application is allowed. Stay up for realization of fine is allowed. Notice on the bail application.
Personal notice.
Restitution. Only for the purpose of bail. Sub item also the same. No, sub item is admitted. It's already been admitted, sub item.
You can say call alarm.
Call alarm. It's already admitted. Daily criminal appeal next is item 19.
Item 19.
6 boxer is there. Issue notice to the victim, public informant. Admit, call for the TCR, and there is no delay. There is no release. There is no application. And appoint the MIT history from the panel. From the panel. Is there any delay? SR report is there?
Yeah, the 9 days delay is
9 days delay. Cut down the delay. Cut down.
So item 20 has been adjourned. Item 21.
21. For hearing. Would you wait for the order? Again, non-APS. Non-APS for the.
No, I will not say yes because of this.
Simply adjourn. On request adjourn.
Yes.
Item 22.
And on request adjourn, release it for final disposal after 2 weeks. Same order here, 22. Release it for final disposal after 2 weeks.
Item 23.
23. Entering application is there.
Page number 3063.
3063. Asking about bail application. Bail application. On joint request, needs the matter 1 week after.
Item 24.
Clear bail petition is rejected on 6/8/24. Now they have renewed the application.
Stand out to next 1 week after any day. 1 week.
Item 25.
Custody certificate. For custody certificate, even though it was granted. Right.
What is that? Produce CA? CA and custody settlement. CA is conduct.
That has not been placed on the constable. The order dated 5/5/2025 has not yet been complied. Then Constable State 6, 1 more week adjournment for compliance of the order dated 5/5/25. Is the matter after 2 weeks.
Yes.
Item 26.
Bail application.
Simply urgent.
Item 27.
Yes, madam. Have you got any report, any of the matters?
Item number 28 and 29. They both are there.
Okay, we are on 24 now.
27.
That's 27. 27, okay, 27. 27, do you have to say anything?
27 is not allotted to me. The other officers are.
And we'll simply adjourn to next week.
Yes.
Okay, next week.
That is stay of relation of fine.
Oh, that is allowed, huh? Stay of relation of application is allowed. And is the matter for hearing. So the bail application is there. Needs the bail application for hearing next week.
Item 28.
Item number 28, Lordship has called for custody certificate, criminal antecedent, as well as report regarding the jail conduct. I have obtained custody certificate as well as the jail conduct. I request some time for criminal antecedent.
Custody certificate, what have you got?
Custody certificate as well as the jail conduct. The only requirement is
okay. Wide order dated 18/8/2025.
Yes.
The State Council was directed to obtain the custody certificate, criminal antecedent, and the conduct of the appellant convict in the jail. Sulakshmi appearing for the state has placed on record the custody certificate as well as the what is this conduct certificate.
Conduct, sir.
Conduct certificate.
Conduct in
And,
jail.
conduct certificate and seeks 1 week time to obtain instruction in regard to criminal incident of the appellant. Release the matter. Time is granted. Release the matter. Taken out of court. This is taken out of court. 29.
Item 29.
In item number 29, Your Lordship has granted interim bail for 1 month on 24/11/25 on account of illness of his wife.
Surrender.
He has surrendered, Your Lordship. As per the report, he has surrendered. Now he has filed another IA for extension of the said interim order.
Extension. But after surrendering.
Yes, sir. So the surrender certificate is
When
flag
is surrender? When is the surrender?
flag E.
Flag E.
Flag E.
Surrender. On 26/11.
26/11 was granted bail.
When is surrender?
26/12, Your Lordship.
26.
According to the convert surrender today. The order number 2.
Okay.
At case
26/12. 12. 25. And he is seeking extension.
The
But
IA
after-
reflects that they are seeking an extension.
On what ground?
Pardon, Your Lordship?
On what ground?
Probably for that, I've not
Once
solved with
he
the.
surrenders,
Yes, sir.
fresh application.
It has to be a fresh application.
Observation.
The other one is flag D. D is the
Application.
application.
And that might have been moved prior to surrender. Isn't it?
So that application has been filed on
Okay.
1912 only.
By order dated 24/11/2025, this court admitted the convict, which there are 2 convicts. One, it admitted
The applicant.
applicant convict to interim
One.
appellant number 1.
Sole
Appellant number 1 applicant.
So the sole appellant.
Sole appellant.
Sole
Okay. Sole appellant to interim bail for a period of
1 month.
1 month. In the meantime, on 19/12/2025, the appellant is moved an application seeking extension of the interim bail granted to him while the order dated 24/11/2025. However, on expiry of the interim bail period, the petitioner, the appellant, has surrendered before the trial court, which is emanating from the proceeding before the trial court dated 26/12/2025. In view of the same, the application moved by the convict appellant for extension of time loses its force. Hence, the same is disposed of. Leaves the matter for final disposal in the next week.
Yes.
After 1 week.
Item 30.
30.
Bill application. Stay of fine. Stay of fine with IA number 33.
Yes, so you allow that, and insofar as bail application is concerned, lease the application after 1 week.
Item 31.
Yes, madam, 31. Bail application. Okay. Lease the matter. From here 32 onwards here. Madam, you tell your colleagues to come that
I have already
reports are not closed. It's only 10-15 minutes we have given a gap.
That's fine.
The only thing is there is a news in the bar that everybody is
Wrong
to
news.
vacate.
Wrong.
This Pathak sir.
After 2 o'clock. Please tell your colleagues.
You just tell times,
Okay?
Call them
Everything is normal. Don't worry about it.
You have received the information.
Yes, my lord.
I number?
I number 84 of 2026. 84.
On 3/11/26, she has died.
Number 30.
Lordship, item number 30. 30.
Serial number 1239.
I have signed the sum of the applicant that were recalled.
May I
Confirmation.
Yesterday only they had been to the house of the or something.
Evidence convict. Move the A number 84 of 2006. Please move the present time seeking interim release from the custody, medical custody, on the grounds that his mother has expired on 3/1/2026. 26. There was no order for verification. The advance copy was served upon the advance copy of the application was served upon the state council, who entered, verified the respect, and submitted a report dated 3/1/2026 issued by the Sarpanch of Hon'Ble Bentapur GP Gram Panchayat. As per the report, the mother of the applicant, Morley Shaw, has expired on 3/1/2027.
There are three appellants. First is the son of the deceased Molisau. Other two are the grandson of that Molisau.
Okay. Right out.
Three petitions.
The petitioner number 1 is the son of deceased Molisau, and petitioner number 2 and 3 are the grandson, son and grandson. In view of the aforementioned, the petitioners are directed to release on bail, interim bail for a period of 15 days. 15 days, so as to facilitate, so as to participate in obscure ceremony. After the expiry of the bail period, interim bail period, they shall surrender and file the surrender certificate. In terms of the
date may be
terms and conditions for release shall be decided by the pleasant trial court.
May I pardon to make a
In course of time, if possible.
Yes.
Otherwise, the certificate, web copy may be acted upon.
Well, say no reference to be active.
Yes.
That is
Usual term.
Grateful.
may I be pardon to make a mention, my lord, item 38. Your lordship, I am appearing for OP number 2 and 3 MCL. A copy of the rejoinder is served to me. My lord.
We are to proceed with it.
I'm sorry. My lord. My lord.
Actually, this matter was already adjusted to that agreement.
No, my lord. I didn't.
Item 32.
Item 32. What about the online proceeding?
Online proceeding will continue?
Yeah, it will continue. You put it, huh? No, only court side.
Item 33.
No, there are no. Usual. You see let the people see the advocates also, that fearlessly they are appearing.
Yes.
Item 33.
You are appearing?
No. And for 32 for state.
32. You are appearing? Who is appearing?
For statement.
That's right. Hello.
Item 33.
53.
Item 30.
Yes. What is this matter?
And what is the from 32 onwards again we will call. Okay, yes.
Seems like it is important.
Okay, 33 passed over.
Item 34.
May I please, Your Lordship?
Yes.
My Lord, my senior was about to argue this case. My Lord, he is not present here right now. So my Lords may adjourn the matter.
Then the matter.
Who is your senior?
My Lords, Nihal Rath.
Huh?
Nihal Rath.
Nihal.
My Lords.
Where is the file? You have file. Tell us the related facts. We will adjourn or not, that's a different story. Tell us the fact. You might have read it.
No.
What is the prayer? Just read the prayer at least.
Yes.
When this file was given to you? In the morning or just now? Just now.
Go to the prayer column. This case is filed under which section of CPC? Or CRPC? Or Constitution?
My Lord, it's filed under clause 10 of the letter of patent of Patna High Court as well as read with.
Letter of patent.
Let the parent do it.
My Lord.
No.
Whereas the prayer was to set aside the order under WPC 32170 of 2011 under Annexure 1, as well as the order of disengagement dated 2/2/2021 under Annexure 6, my Lord.
What are those orders? Which is that annexure, brother?
My Lord's Annexure 6, my Lord. Order of
6 page number. Which order you want us to quash?
My Lord, the order under my Lord, the order which has been passed by this honorable court in WPC number.
What was that matter? Why learned single judge passed this order? And who were you? You were the petitioner.
My Lords.
So petition is rejected, dismissed.
You read the operating part of the impugn order.
My Lord's part. My Lord's,
you are appearing for whom?
Your Lordship, I am appearing in the second sub-matter on behalf of Mr. Rautra, senior
Petitioner.
Yes, for the appellant.
Appellant. Appellant was petitioner or respondent in that case?
The petitioners.
So learned single judge declined relief to you.
Your Lordship, I am not acquainted with the facts of the matters. Kindly provide me some time.
Not reading file. You should have filed. When you got the file?
Today.
Today what time? Morning.
After I got the court.
After this
Lordship, kindly pray for an adjournment.
But whenever you get the file, at least read the prayer portion and the relevant facts, minimum facts,
My apologies.
and encase this opportunity to speak in the court. You may not get this kind of opportunity once again.
My apologies.
After 2 weeks.
Yes, sir.
After 2 weeks.
My lord, interim order was there.
Interim order is there.
Yes, sir.
Nothing order to continue.
National.
In order, if any, shall continue the next day. Yes.
Item 35. Item 35.
Pursue. Next.
Item 36 has been adjourned. Item 37.
Your Lordship, I am for OP5 in the matter, Your Lordship.
Somebody is appearing online.
Your Lordship, I am appearing for OP5 in this matter, Your Lordship. Opposite party number 5. Federal Selector, Your Lordship. But I believe, Your Lordship, petitioner is not here yet. I have been impleaded in the matter, Your Lordship. We have already filed a counter affidavit as well, Your Lordship.
This is for final hearing.
Your Lordship, I think a few counter affidavits are not on record, Your Lordship, I guess. So I'm not aware if it is for final hearing, Your Lordship. But petitioner was there in the morning, but after that bomb threat, Your Lordship, after the evacuation, I think nobody is appearing yet.
Yeah.
Your Lordship, as per the discussion, if the matter can be taken up on 21st of January, as it was discussed, we were discussing the matter, if it can be done on 21st of January, Your Lordship.
You have discussed and decided the date also.
No, sir, no, Your Lordship, I have not decided the date. I am just saying if it can be done for 21st January, sir.
Item 38.
21st January, Your Lordship.
Yes, yes. Since you have decided, I'm agreeing with you.
Much obliged, Your Lordship. Much obliged.
Yes.
38.
Item 38, my lord, I am appearing for OP number 2 and 3. A copy of the rejoinder is served to me just now, my lord.
Great.
I'm appearing for the petition.
Rejoinder is given just now.
Yes. Yesterday we have filed, today we have served the document.
What is the matter? Just
My lord,
preliminary. We are not passing any order if you are not ready. Yes, we want to know what is the case.
my lord, here they have asked for a refund of the bank guarantee.
Return of the bank guarantee.
Yes, return of the bank guarantee. I stand corrected. And the other prayer is refund of the amount already deducted.
Bank guarantee is not encased.
Bank guarantee is not encashed. In fact, they are renewing it also. So now, my lord, though there is counter and rejoinder, everything is there, but in view, if your lordship sees the prayer, my lord, the prayer is basically for a
Who are you? Who are you? You are bank.
OP number 2 and 3.
The bank guarantee is an in your favor.
Yes, my lord.
Bank. Who is bank? Then bank is 4.
Bank is 4.
Yes.
So, my lord,
Why bank guarantee was given?
pursuant to a tender. Pursuant to a work awarded in his favor. So,
Performance guarantee.
yes, my lord.
Performance guarantee.
Performance guarantee.
Yes, my lord. Performance guarantee was for.
So, no due performance of the tender work?
No, my lord. So, my preliminary submission would be that, my lord.
Any arbitration clause is there?
I'll check. No, my lord.
Arbitration?
No. The settlement of dispute is there. He has to approach the engineer in charge.
For settlement of dispute.
Settlement of dispute.
Engineer in charge is your department.
Yes, my lord. Gentleman.
That latest judgment of
Yes. No, that's why he said that that cannot be an arbitration clause.
Which is that clause? Show that.
Clause.
He cannot be arbitrator, conciliator.
No.
But other person we can substitute.
Yes. My lord, there is a dispute resolution. It is not an arbitration clause.
But a dispute, how it is worded?
I'll just.
Need not say so many words arbitration, etc.
Whether it can be constituted as arbitration clause.
No, my lord.
Then section 11.
No, it cannot be construed as arbitration.
See that.
I'll just sit to
which page? Generally, these are
page 52.
52.
Yes, 52 of the brief.
Go to 52.
Clause 12.
Yes.
Clause 12. It is incumbent upon the
settlement of dispute.
Yes, ma'am.
It is incumbent upon the contract.
To avoid litigation and disputes during the course of execution. However, if such disputes take place between the contractor and the department, efforts shall be made first to settle the disputes at the company level. The contractor should make request in writing to the engineering charge for settlement of such dispute, claims within 30 days of arising of the cause of dispute, failing which no dispute claims of the contractor shall be entertained by the company. Efforts shall be made to resolve the dispute in 2 stages. In the first stage, dispute shall be referred to area GM. If dispute still persists, the dispute shall be referred to a committee constituted by the owner. The committee shall have one member of the rank of director of the company who shall be the chairman of the company. If dispute still persists,
Differences persist.
I'm sorry, I start. If differences still persist, the settlement of dispute shall be resolved in the following manner. Dispute relating to commercial contract with central PAC, government department, except railways, income tax, custom and excise duties, the state public sector enterprise shall be referred by either party for arbitration to PMA, Permanent Machinery of Arbitration in the Department of Public Enterprises.
Yeah.
That's a PSU. But if that's a PSU, Malad, if it is between 2 PSUs, then this will apply. Permanent mechanism of arbitration. He is not a.
If difference is why do you say that?
Malad, dispute relating to commercial contracts with central public sector enterprise, government departments, except railways, income tax, custom and excise duties, or state public sector enterprises shall be referred to either party for arbitration. So if it is between 2 central PSUs, only this.
No.
Yes, madam.
No.
Not like
You have to read in continuation.
Yes, madam.
This last clause has to be read in conjunction with the earlier one.
previous clauses.
Yes,
So read it in conjunction. Then you will see if the differences still persist after making all the efforts which has been given.
Yes.
Then what you have to do is this settlement of dispute shall be resolved in the following manner.
Yes, madam.
Dispute relating to commercial contract. Commercial contract is a commercial contract.
Yes.
With each one of the party is maybe a central public sector.
Yes, madam. No.
Yes.
Yes, the last line. My lord, may I take your lordship to the last line? In case of parties other than government agencies, the redressal of the dispute may be sought in court of law.
Parties, court of law,
Other than government agencies.
My lord.
These are not government agencies.
No, these are not government agencies, my lord.
The redressal of the dispute may be sought in the court of law. Means no arbitration at all.
No. My lord, my standard contract is this. So, my lord, their arbitration is not a.
Therefore, they are maintaining the writ petition. They are filing the writ petition.
Maintaining a writ petition, but my lord, my idea is that they could approach the civil court.
No.
Common law.
The other settlement
my lord,
procedure which has been contemplated in 12 has been undertaken by them or not?
They have approached the engineering charge.
You have rejected that.
Yes, my lord.
You have rejected that.
Yes, my lord.
Thereafter this rate.
Yes. So, my lord, primarily, if your lordship sees the prayer, if both the prayers have to be taken to release bank guarantee and to release pending excess penalty amount. So both the prayers are money claims. That's my submission.
On what basis you want to invoke the bank guarantee?
No, we have
a due performance.
Yes, my lord.
That's your case.
No, my lord, yes, there is no due performance. We don't intend to invoke the bank guarantee. We have not release the bank guarantee, because in the meantime, he was able to execute only 22% of the work. It is my case that 22% of work, and so he is liable for some deduction. So if that amount is to be deducted and is to be returned.
Have you determined that?
Yes, my lord. It is there.
The problem is these are completely disputed.
Yes, my lord. That's the
what percentage of work you have done, how it is done, and all this.
Standard of work.
In a REIT jurisdiction, to what extent we can?
Your Honor, my only humble submission is I am a resolution applicant who has taken over the company, the corporate debtor, through a CIRP proceeding.
So you are not liable at all. Is your
I took over the bank guarantee as well from the.
You stand in the shoes of the other party.
Bank guarantee, the entire bank guarantee was taken as an asset.
Yes,
in the resolution plan. So as the resolution proposal.
Yeah, we have taken an amendment. If there is an order of this honor.
Why should we? It is your case. You have to show us whether the entire bank guarantee amount was taken as an asset in the resolution proposal, or after deduction of the extent of work we have performed. That has to be seen.
Yes, in fact. No, I'm sorry.
The entire bank guarantee has been taken over by the resolution applicant in the resolution.
Then see section 9 and section 7 application also required to be seen whether you have disclosed this fact that partly work I have done and partly work I have not done. If you have not disclosed it in the DRT proceeding, in the NCLT proceeding, then you can't take advantage of that.
And produce
you might have misled the NCLT resolution professional, saying that this is my asset, but this asset is not exactly, the entire asset is not yours. Part of the asset has to be, part of the money has to be deducted. That you should have disclosed to the resolution professional.
The money that has to be.
All this has to be seen. Otherwise,
2017 Supreme Court Justice Nariman's judgment.
Very much.
Yes, that is the position.
Because you can't take the benefit of that today, because you are the successor. So that those pleadings has to be there.
And that
document has to be placed.
Yes, my lord, that in any case, if they show that the bank guarantee they have, that cannot be a asset without a liability, I believe, my lord, because it's my lord, that's my submission. So, my lord, in any case, that would not help him.
In my submission, the penalty that they have taken towards the performance guarantee that we have not performed the work, that has already been deducted from the invoices of the petitioner. The corporate debtor who was before the.
What is this matter, Mukherjee?
Well, the petitioner is the creation of a reconstructed company, LLC. When I took over the assets and liabilities, one of the assets that was to come into my hands was an amount of about 6 crores, which is lying with the Mahanadi coalfields. Now, this amount, they acknowledge the fact that this amount is with them. They acknowledge the fact that it's payable to me, but they were holding on to it on the plea that one of the erstwhile creditors, operational creditors, had put forth a claim. Saying that he had done certain works for the erstwhile company and was to receive some money out of that. Now, your lordship knows that whenever under the IBC, whenever a reconstructed company comes into existence, it comes with the clean slate policy. That is the judgment of the Supreme Court. Ghanasham Mishra's case, clean slate, so that I am not taken by surprise by any liability which is not
mentioned in the
resolution process.
Precisely, we are asking.
This, my lord, in fact, the resolution plan will show that this claim was there before the creditor, before the committee of creditors. It was a resolution professional. It was before the resolution professional. Now it was struck off. the resolution professional decided this amount.
Mahanadi Coalfield was a claimant there?
No, they were not.
No, my lord. I'll address you. My learned senior.
You are at best in operational creditor.
No, my lord. I'll just clarify, my lord. My learned senior submission to the extent that I am holding on to the bank guarantee because there is some other company's liability which is to be settled on you. No, that's not true. That's not true. He is not incorrect. It was our stand for quite a pretty long time. But in the meantime, my lord, those things stand cleared because that litigations are all over. So that my consistent stand in my counter affidavit, why I am holding on to it, is at page 6 of my counter affidavit, which reads that the deponent further reiterate that there being an amount of rupees 1,62,62,344.82 being liable to be recovered from the contractor.
That's what precisely we are asking you. The contractor from whom you are liable to recover,
petition,
whether he had gone to NCLT proceeding.
No.
The contractor has gone to.
It is the petitioner. Here contractor means the petitioner, my lord. Because he is
taking the suit.
Yes.
But when the NCLT proceeding was going on, have you claimed it?
No. Never.
Then you forfeit it.
Then, my lord, here there is a bank guarantee which was directly.
Contract.
The NCLT proceeding, entire pleading has to be placed.
Yes,
that will be we can.
I have them now. I can place it right now.
No, that you have to give it to him. He has to look into it. It will be many pages, sir.
My lord, in fact, it was annexed in the other proceedings that were brought forth by the other so-called creditor, where MCL was.
If you are not confused, you have stepped into the shoes of the contractor.
I have stepped into the shoes of the contractor. Yes, my lord.
Contractor suffer the NCLT proceeding.
Yes, my lord.
Right.
Yes.
Obviously,
yes.
On by way of an application of 7 or 9, by the creditor, either operational creditor, financial creditor.
Yes, my lord.
And that resolution proposal was placed, and you succeeded there.
Yes.
Whether in that resolution proposal, publication was done, and Mahanadi Coalfield claimed that amount, that particular
publication was done. Mahanadi Coalfield did not make any claim there.
Then
they did not make any claim there.
I could not have, because it was a live contract within the CIRP period.
Those things.
So, my lord, how can
those things we can't adjudicate?
No, yes, my lord, but I could not, because unless the amount is crystallized, I cannot
cannot put the claim forward at all. Is your contention?
Yes, my lord, because
by that contingent on performance.
Yes, my lord. So, my lord, here is
that you say some percentage of work has been
only 22%, my lord.
That 22%, what is the cost? You should have put it.
I have put it here, my
not
lord.
here.
No,
before I
because it doesn't turn up.
That did not arise at all. Yes, but
no, that did arise.
No,
that did arise.
When this 22% was assessed.
That's before the IBC proceeding or after the IBC?
That is after. You are right. If it is before.
But it could not have been after.
No,
it could not have been after.
No, its performance is if the
contract completion date was 22. The IBC proceeding got over in 21. So, my lord,
after that,
yes, my lord. The contract period gets over after. My lord, in any case, I will come up with the exact details if not, because the rejoinder is handed over to me just now.
That's right.
My lord,
Then he is entitled.
December 20.
You are suffering that time.
The contract period was over. The period was over.
Yes, sir.
Yes.
And the resolution plan, my lords, was finalized in December 22.
I know that is the problem. You have to get over this.
Yes, ma'am.
If they would have been a contractor, situation would have been different. They stepped into the shoes of contractor after cleaning everything. They have taken the company after everything is cleaned up.
In other words, the doctrine
That's the idea. That's the idea
I cannot be taken by surprise. Today, if somebody comes and says that I have to receive 1.5 from you, you can't be taken by surprise.
The entire IBC idea is
frustrated. It gets frustrated. And that is exactly, Ghanashyam Das, that is exactly what
that is the principle.
The entire statute gets frustrated otherwise.
When IBC proceedings start against a company, a publication is made asking everybody by who owes anything, you tell us. So once everything comes, the resolution professional sits together, assets and everything, liability, everything is cleaned up, everything. A cleaned company is given to them.
That's the object of it.
Then they can proceed with the company.
My lord, you may appreciate there is a bank guarantee which is stated to be an asset. Bank guarantee has a separate contract. There is an underlying contract. So, my lord, it can only be an asset subject to the dues because they have been asked
whether in the proceedings, IBC proceedings, whether it was treated as an asset or not, which my brother said.
Yes, my lord, that has to be checked. And I find the direction there. No, I'll have to check that, my lord. But I find a line that they were asked to renew it. So even in the CIRP, the resolution order approving the resolution, they were asked to renew that bank guarantee. So, my lord, probably the Honorable NCLT also had a inkling in mind that there may be some liabilities for which it has to be considered. I'll have to assist your lordship better, my lord, to come up.
You have to give that resolution proposal and all.
My lord, that senior has already annexed.
Entire proceedings copy you have to give. You just look into. Furnish, Mr.
I may be pardoned, my lord. We have also filed a case where we are the subcontractor of SICA.
He's the one who had filed the series of cases, not one, series of cases.
Let me
right up to Supreme Court, where he has lost.
If I am aggrieved over, I have to go to Supreme Court. Apparently, you don't go to Supreme Court.
No, there also he has lost.
No, I made loss, but that we have a case, my lord. We want to show.
Who are you, by the way?
My lord, I am the subcontractor.
His intervention has been rejected.
I filed a writ application where I have challenged some 1,000 crores he has taken away. He has not given anything. Now he says that I have some other company has come in and they have taken. Now, my lord, all these poor people, they are suffering because of him, my lord. And my lord,
but you lost the case up to the apex court.
No, that is on a different contest, my lord.
No. Different same contest.
No.
I don't have a
copy.
No, I don't have. No, my lord. Another read application.
Next, the details of the applications which have been discussed.
I will give the number of that read application.
You are the subcontractor up to the main contract.
Yes, main contract.
The main contractor owes something to you.
Yes.
Isn't it?
Yes, ma'am.
Have you participated in anything?
No notice was ever given to me.
Notice was never given.
My lord, it has been stated.
He had participated.
My debt and claim was shown in the record. Now they say that a clean sheet or clean slate has been given, so that is not to be taken into account.
How the resolution professional has dealt with your claim?
Yes, that is what my lord I have challenged in my writ application. Let that writ application come on the board.
Along with this.
In this instance,
I have a writ application, my lord. That is your writ application.
Bring it with in that other
No, sir, you telling that resolution proposal approval reject orders.
No.
NCLT.
I know to show how it has been, how my right been taken care of, my lord. I have filed that writ application, my lord, because I am not in a position, neither in a.
Are you a party here?
No, intervention application was rejected, but with a rider that I can pursue my remedies.
No, first you are pursuing it.
Yes, I am pursuing with a filing of a writ application. I want that it should be amended.
In the writ application also, this division that the pendency of the writ application shall not come in the way. Basically,
I'm only praying that it should come on the board. It should be heard. I may not have a right. My lord may decide otherwise, but let it be heard.
It is the same thing which cannot be done directly will be done. His intervention is rejected.
My writ
application, whatever is
has not been rejected. My retirement is still there.
Apart from my silences also. No silence.
I'm sorry.
Your lordship may see order dated 1/10/25.
That petition comes before who? Is it single judge or
yes,
before this court?
No, this division mentioned IBC.
That also then. Together we will have a push call that matters also.
Your lordship may kindly see order dated 1/10/20. I'll tell your lordship why. Kindly see order dated 1/10/25.
My lord, sorry, my lord, today about the situation, I am not in a mental frame of mind to argue further. My lord, let it come.
Are you responsible for all these things?
No, my lord, because it has.
Why you are not in
No, my lord,
he is not here. He has
today, my lord is very much aware of it.
Mr. Mukherjee, let this matter come tomorrow. Or
Not
day after, along with that matter.
Yes, let it.
He will argue his matter. You argue your matter.
Yes, your lordship, may I make a submission to your lordship? Your lordship may hear his matter tomorrow. Take my matter thereafter, not along with his matter.
Why? Not along with
no, my lord, I am saying your lordship may kindly that this exercise has already been done by this honorable court. I don't want another bench to be again vexed with the same issue. Kindly see order dated 1/10/24 passed in IA number 8076.
Correct.
In this writ petition.
We will hear tomorrow.
No, this has already been heard and disposed of.
My lord is saying about the other matter.
Other repetition, my lords. Other repetition, let it be heard separately. Not because your lordship sees what is happening.
May I only submit?
What is happening, your lordship see. Whether your lordship will entertain that writ petition or not, your lordship will decide, and thereafter I will have a say in that writ petition.
Okay. So we will hear his matter first.
Your lordship can hear his matter.
I'll give them.
Give that.
I'll give that.
In the present writ application, your lordship may allow me a little more time to examine those documents.
Very well. Anyway, he himself says that after
Yes, my lord.
that matter we can take up this matter.
Yes.
I'll give it now. Understand?
Now, call that matter on Monday. This matter Monday after next.
And in this matter, you place on record.
Yes, my lord. My lord, that he has already.
It's already there on record. I'll show it to your lordship when your lordship.
But why I wanted it together, we wanted it together, suppose if his client has, if the appellant or petitioner misleads her, there will be nobody to point out that petitioner is misleading, not your lawyer.
My lord, I'll show orders with regard to this particular list. I will show
who are parties there. In your,
I am the party there.
Yes, my lord, he is the party.
We are the party.
Both your parties.
Yes.
No problem.
Then both the matters can be heard.
Therefore, I am suggesting.
Yes.
Your lordship, in that case, your lordship may fix it to Tuesday. I'll give it.
I'll just give that up. I'll give it.
Yes.
While he will argue his matter,
Sir, you argue.
your application for intervention is rejected, he will not stand up.
No.
My lord, in this writ application.
You can argue your writ petition, no problem. But when his writ is argued, you will not stand up.
That is exactly what has happened today. That is exactly what has happened today. He sabotages my case.
Mr. Mukherjee says that let his writ petition be heard separately.
No, he's in
not intervention.
Request for a writ petition.
Yes. I'm terrified of that. Not afraid.
Only
terrified of that.
Request for implement is rejected. That's all.
Yes,
not only that.
To Supreme Court.
No. He has filed He had filed writ petitions 1, dismissed. Writ petition 2, dismissed. Third, arbitration application, dismissed. Commercial court application, dismissed. Supreme Court, dismissed.
This has been adjudicated already.
Thereafter, he filed an intervention. My case,
These both the matters.
My lord, with this matter, my lord, I'll need a little more time because I have to send this copy and obtain instruction, my lord, in this matter, only this written application.
Both the matters then.
Then after 2 weeks.
My lord, obliged.
After 2 weeks.
Your Lordship may fix a date, my lord. Kindly fix a date.
Not, my lord, on 27 and not within 27 to 30th.
Within or
After that, my lord, after that.
then it will go to
February, my lord.
February. No problem.
My lord, no problem.
It's me who is suffering because it's my money.
I'm also no problem. He to get something.
2nd of February. Yes. After hearing your argument, our bomb scare went away. Other scare started.
No, the bomb did explode here.
Yes.
Item 39.
There is a lot of complaint from the board members that you told us to leave the premises. Now you are saying that the court has to resume. So that is the whole problem, my lord. So some are.
We're not passing any address.
No, we are not passing any address. Only those who are present will hear them. Those who are not here, it's not damage their matter.
Honorable Chief Justice told me that we will seek to give a message that
otherwise, whole institution being held up for a ransom.
Yes, ma'am.
We are against it.
This is my first time that Odisha High Court is facing such kind of a threat.
Therefore, we should be careful.
The security has to be tightened, my lord. That has to be looked
And
at.
if you people will cooperate, it will be
Yes, my lord. Everybody will cooperate. That the security system that has been installed in Chennai and also in Supreme Court,
Apex Court,
that has to be
copied here.
Stop it over.
the proximity cards and
Everything.
We are not damaging our words. We are not damaging any man. We are not here.
Simply adjourning.
Item 39, 40, 41 have been adjourned. Item 42. Item 42.
My lord, this is the matter.
Your opponent is here. No.
Union of India.
Union of India.
No, they are of state of Orissa. Union of India is not there.
Yeah, bring Mr. Hari.
Maybe somewhere else today.
It's a matter regarding cancellation of total selection of departmental promotion quota in East Coast Railway. There is no allegation of malpractice. There is no fault with the candidates. After there is advertisement, a cut-off date fixed, and everybody applied through various departments. Those have grade pay of Group C post, grade pay of 2,400. So 5 departments, commercial, ticket, and all their departments clerks have filed their candidature for the selection, the written examination. Then one eligibility list published, and there is also a cut-off date. If anybody left out in the eligibility list, may come after 6/3/2024. Nobody protested. Then examination conducted. Then a selection list published. Then 6 persons alleged that there is ambiguity in the notification, and the entire selection process cancelled by the division DRM.
Was there ambiguity?
No ambiguity, because Railway Board examination, there is a Railway Board circular. As per that circular, notification issue.
Those are the 6 persons, those who complained, have they participated in the examination process?
No, my lord. They stated we didn't understand that what is the...
Who are they?
There's a ministerial staff having no eligibility to participate. They have not completed 3 years.
They have no eligibility.
No eligibility. But in the meantime, they have been promoted during the pendency of the original application in their own department. This is there is different examination, my lord. Department.
Therefore, what you say is Hamma Prasad is not applicable at all.
No, my lord, I have come up with a judgment where it is stated, even if there is a malpractice or anything.
Wholesale way you cannot do.
You can't do.
Yes.
Wholesale cancellation.
Cancellation. We are all in verge of retirement result we get before this one and Law and Tribunal.
And the 6% those who complained, they don't have any grievance now.
No, they were
Because
not
they are
eligible
promoted.
also.
They're
Now they are promoted. They are not.
promoted in their own. I have annexed that.
So therefore, they might have lost interest in this litigation.
And this is my out of my lord, this case I am submitting. It is created by the authority to cancel whole selection.
Why?
Favor someone.
Because my lord, that's the reason. In Bhubaneswar division, they have allowed to join those have selected. In Sambalpur division, entire selection process cancelled, making a plea that some persons have complained. And that complaint after publication of result when selection list published.
Selection.
5/8/2024.
Select list was prepared.
And everything. And after 1 month, they have given the complaint that it is, my lord, that I have annexed 89. Taking that into consideration, they totally, my lord, 87.
What the tribunal says?
Tribunal said we have not made them parties, these 6 persons. And in the counter, they have disclosed this. You know, count, my lord, kindly see 147. It is also
no. If they are even if they are otherwise ineligible, making them parties will not serve any purpose.
And the tribunal, the
what is the where is the objection of the union government railways?
They have the counter I have annexed, my lord. That counter I have annexed, entire counter. Page 58, they have stated that.
You read that cancellation order?
But the tribunal says that those people were
you have not accrued any right to appoint. And those people I will not make parties.
The eligible candidates were debarred. Therefore,
that we are showing, my lord. In the counter, they are stating, even if, I will kindly see that.
That is the finding.
Page 63. Page 63, para 10. In reply to aberments made in 4.3 and 4.4 of the original application, it is humbly submitted that the written examination was published on 5/8/2024 and the proceedings for panel formation were still underway and the panel was yet not approved. Meanwhile, a joint appeal dated 11/9/2024 was submitted by 6 commercial clerks cum ticket collectors of Sambalpur division, stating that their application forms for the said selection were not forwarded by their controlling supervisor based on the stipulation mentioned in the notification, that is
3 years.
3 years. But kindly see that is the and it is also 3 years. The notification, the annexure 1, my lord, kindly see eligibility and service condition of staff. Staff working on the following categories. My lord, there are 5 categories, and commercial department with a minimum of 3 years of regular service in respective category and post as on date of notification, that is 10/1/2024. Authority RB number 46 of 2017 and 2018 and 19. That I have annexed, my lord. The as per notification issued as per the Railway Board notification, page 122, my lord, 2017. It is also said 60% by general selection from amongst serving regular employees with a minimum 3 years of service.
Even there it is 3 years.
Yeah, 3 years also. That in the counter they are stating, saying
Since they did not have 3 years regular service, their applications were not
no, they have never
forward.
They have never filed.
No, they have said somewhere. I just read.
My lords,
They had
they are in the counter. They have stated.
Concerned head of the department did not forward them.
My lord, page 40. That is the notification. Willing and eligible applicants who fulfill the above eligibility criteria will submit their application in prescribed. They are not willing. Prescribed pro forma enclosed herewith to their controlling supervisors on or before 30/1/2024. Who will forward the application in one bunch to the branch officer on or before 2/2/2024. So they must be willing. And the eligibility test list, my lord, published, Annexer A by 8. And that is page 89, my lord, kindly see. That is on 28/2/2024. After the last date of application, on 28th February, they have published 24, the eligibility list. Representation, if any, last paragraph, regarding the list as enclosed may be submitted with the relevant proof on or above 6/3/2024 to undersigned. Otherwise, representation received beyond 6/3/2004 will not be entertained. And
When representation was made?
yes, that is at 9th after publication of result.
So obviously it will be after this date.
My lord, that is
this
page
should not have been acted upon at all.
No, my lord, that's page A by 7, Annexer A by 7, page 87.
You have a good case, madam. You have to call them. That's all.
You bring your opponent.
And the good
Last time you have answered all the questions put by us.
I'm
Which you
so
didn't do
sorry.
yesterday.
I'm so sorry. I am so sorry. On the last, yesterday I was just.
You are like Rani Channamma for High Court.
That is my mistake.
You tell him. No.
You have a good case.
Nothing like that. You argue your case for you.
That's, I know, my lord, this bench will never do any adverse. I am so sure of that.
Yeah.
Even if that is dismissed by your lordship.
No, you are not dismissed.
Even if somebody said me it is dismissed, no, that something will happen. This court will never dismiss like this. That something happens, my lord, with us. And
No, we are so predictable. Predictability of a bench.
We are predictable to madam.
No. Your lordship is last. Both these benches, for the last minute, the mind is open. How the relief can be granted that way. So I am pretty sure that something will happen.
Get ready.
You pick who your opponent.
Manoj Patti, my lord, he is not there. You can.
We'll post it next week.
Next week, partly heard, so that for next week, Tuesday. No, sorry. Otherwise,
My lord, they said everything is fine.
Item 43.
Call next week. To enable CGC to comment or to.
Whoever is present, please, they have a case. The not present is let know that.
Yes.
Item 43.
Oh. Yes.
My lord, item 43, I'm appearing for Union of India. My video is not working. But I was praying for time, my lord.
May I please, your lordship? Your lordship, I am the petitioner. Lordship, in this case, what happened? That the petitioner is the successful auction purchaser, lordship, conducted by bank on 25/7/2016. And the same was accepted and confirmed by the bank by Annexure 1. Petitioner already fulfilled all the terms and conditions and deposited the entire bid amount, your lordship.
You want sale certificate?
Yes, lordship. And over the 9 years, deliberately they are not handed over the physical possession. Neither they are giving the sale certificate, your lordship.
Which bank?
2016.
Bank of Baroda, Kotak branch.
2016. You have paid entire money.
Entire money, all the terms and conditions we have fulfilled before due time. They are deliberately avoiding the same.
We'll call this matter next week.
Yes, lordship.
To enable your friend to come here, na?
Yes, lordship.
Who is appealing for the Bank of Baroda? Now, Bank of Baroda is now merged with another bank.
Your lordship.
So that may be the reason services may not be effective.
The service is not complete.
Complete only except opposite party number 5.
5. But who is 5?
5 is the real owner of that property, your lordship.
Baroda.
Yes, lordship.
Bank of Baroda is now merged with another bank? I think it is merged with another bank.
I have no instruction.
Maybe. Yes.
Yes,
Let us see.
Obliged, lordship.
Next week. But he is other side, he is not served. Owner of the property.
Maybe his receipt, I have no.
Just check it up, sir.
Just service supplies. We cannot decide this matter.
Take
It is necessary part.
Lordship, our grievance is not against OP number 5. Our grievance against the bank only, a bank of
position check in the record. The service is complete or not.
Correct. As a formal party, you have implemented.
Yes, Lordship. Though he was in physical possession of that property, therefore we made him as a party.
Be interested also. Service complete. Take it up.
No, once service is not done, we cannot take up the matter. Because you have implemented, whether necessary party or not, you have implemented.
Yes,
So
Lord.
service has to happen. Or you have to give up that party.
We may delete that petition.
Yeah, if you make a memo, we'll accordingly delete.
Yes, Lordship.
You are filing memo.
No, Lordship.
You will
Because-
let notice book.
Yes, Lord.
Take fresh steps.
Notice was already, but
Not yet served, na?
Have you checked notice is served or not? Postal.
a noting was there in which it was written that
Huh?
it was written that
Written saying what?
this is the
Deceased.
yes, Lordship.
Then you have to bring a large and all.
So you think whether you can file a memo to seek a deletion.
We will delete his name because our grievance is not against that particular person.
Give a memo.
If you give
Yes,
a memo,
Lord.
we will
We
take.
will.
You will file that. You will consult and
Yes.
yes. Call next week.
Report it. Notice was issued to on a wife who is reported to have been died. The postal report remark indicates that the respondent number 5 is dead. In view of the said development, Learned Counsel for the petitioner seeks an adjournment to obtain instructions from his clients, from her clients.
Is the matter next week?
Next week.
Come with the memo.
A deletion.
You have to bring a large on record. So many things has to be done.
Yes, Lordship.
9 years you gave entire money.
Yes, Lordship. On that, we have deposited the entire money, and the same was accepted on 25/7/2016, Lordship.
This bank is
Yes.
Item 45.
Next.
You argued well.
Yes, Lordship. Thank you.
You argued very well.
We have blessed us.
Item 45. Item 46. Item 47.
Item number 46 is an appeal against acquittal, Lordship. It's an appeal against acquittal.
Item 46.
46.
press admission.
The
Right.
question, the last question, Your Lordship has cited whether state is taking any steps for.
Yes.
As of now, there is no proposal regarding the filing of appeal against this acquittal judgment. May I please?
As of now means you can take.
That is my.
You have been in this matter.
The instruction dated 13/11/23.
No proposal for filing of the appeal is received. But you have filed appeal how?
Your Lordship, this is an informant's appeal.
Informant's appeal.
Informant's appeal against acquittal.
Therefore, that's what we are.
Yes.
See,
He also could have preferred appeal.
yes, yes. Why the order dated 8/9/2025, the State Council was his name. The State on 8/9/2025, the Council for the State sought time instruction regarding instruction as to whether the state is proposing to challenge the impugn order, whereby the opposite party, whereby opposite party number 2,
2 to 5.
2 to 5 have been acquitted from all the charges, all the charges. The informant has preferred the present appeal. Subhalakshmi, Learned Counsel for the state, has placed on record the instruction received from the Directorate of Public Prosecution dated 13/11/2025, which reads in view of the aforementioned, means the criminalities preferred by the informant against the judgment applicable for tax case. On admission, it is not has been admitted on admission.
No, it is not. Notice has to be issued before admission.
Yes.
Since it is
Then let us see whether any case is made out, then why should we issue notice?
Yes, sir. Yes.
Item 47.
47, Your Lordship has parted it day before yesterday. The appellant is.
Oh, okay.
Yes. Can I pray for tomorrow?
It's only next week.
Much pleased.
Item 48.
Who is there? For hearing?
For hearing.
Up to 3 weeks ago. You can't hear. 2007 matters. 49 also same.
Item 49.
49 when the present matter in court matter, but all the associated went to the house matter after the review matter.
We have it next week.
Next week after it. 49 and 44. Only for Arjuna I came from.
You should have gone and you should have told your associates to
Both the matters matter.
49 for 50.
50 matter.
Yes. You're ready with the matter.
Right, I'm ready with
them.
State Council.
State Council.
As it is adjourning to next.
No, we are get ready so that.
Plus a good case, my lord. Though it is a double murder case, my lord, but in fact there is no eyewitness to the occurrence. The case based on the circumstantial evidences, my lord. 3 circumstantial motive and a reading
circumstances speaks better than the witnesses.
It is a case, my lord. 3 circumstances read by the trial court, my lord. Since time is there for that, my lord. 3 circumstances read by the trial court, my lord. First motive, then my lord extrajudicial confession, then my lord the leading to discovery. 3 things, basically on 3 things, the trial court convicted the appellant. Admittedly, appellant is the husband of the one of the deceased. There are daughter and a wife murder in this case of the present appellant, my lord.
Oh, my lord, not three circumstances, other circumstances also there. Well, trial court has not dealt the matter, but evidence are there. The circumstances are number 1, motive, number 2, extrajudicial confession. Number
for that, what is that extrajudicial? Not 162,
not
other than 164. All will be extrajudicial.
Extrajudicial confession. 3rd circumstance leading to discovery of the weapon. 4th circumstance, the cause of death. 5th circumstance, last sin.
Last sin is there.
Yes, and the 6th circumstance, burden of proof, 106. The blood was found in the house of the accused.
Chemical examination was done.
Yes, madam.
Report is there.
Yes.
How accused is related to the
husband and father of the deceased.
Husband and father. Any character issue was there?
Yes.
They belong to which community?
Community, my lord.
Because certain communities take that aspect very, very seriously.
Chosa. A farmer.
General caste, OBC.
But the husband remains silent. The wife has extramarital relationship with number of persons. Remain silent. On the date of occurrence, he killed and he lost the report that my wife is missing.
Okay.
Where the body was found?
The body was found near the railway track.
And death
due to cutting of head.
Severing of head or
not completely.
Well, asphyxia.
Stabilizers.
Item 18.
Any pastoral matters ready?
Item 18, my lord. It's a fresh matter, my lord.
Fresh matter.
Fresh appeal matter, my lord.
Criminal admitted and
admitted. So you have to remit your fees in the court system.
Grateful, man.
Yes.